confirm, sir, that this witness statement has been disclosed to call participants. Mr. Donnelly's evidence is relevant, sir, both to phases 4 and 5 of the inquiry. For the purposes of phase 4, can I please indicate that paragraphs 1 to 43 are to be treated as read into the inquiry's record? Although I do not intend to read the content of those paragraphs now. As a result, this evidence may be taken into account by you in due course, even though it has not been the subject of this hearing.
All right, thank you very much.
Thank you, sir. May we please call Mr. Daly?
Yeah.
Repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you.
Could you confirm your full name, please, Mr. Daly?
Robert Daly.
Thank you for coming to the inquiry to assist it in its work. As you know, I will be asking you questions on behalf of the inquiry. You should have hard copies of 2 witness statements in your name in a bundle in front of you. The first is at tab A1 and is dated the 7th of November 2023. If you could turn to page 39 of that, please.
I have that.
Do you have a copy with a visible signature?
Yes, I do.
Is that your signature?
It is.
The second statement is at tab A2 and is dated the 27th of December 2023.
Sorry, I can't repeat that.
Do you have an A2 in your bundle?
No, I don't.
So my apologies, we're just obtaining a hard copy of the second statement for insertion in the witnesses bundle.
Yes, of course.
Sarah, I understand the document is being printed. I don't know if you would rather that we broke for 5 minutes or whether you're content to remain on screen.
No, let's just get it done, and I'm happy to sit here.
Thank you, sir. Mr. Daly, do you now have a copy of a statement in your name dated the 27th of December 2023?
I do.
Could you turn please to page 12 of that statement?
Yes.
Is there a visible signature on that copy?
Yes, there is.
Is that your signature?
It is.
I understand that there are some corrections which you wish to make to your written evidence in light of documents which have recently been provided to you by the inquiry. Is that correct?
Yes. Yes.
Would you like to make those corrections?
Yes. In my second statement, I stated at paragraph 25 of my first statement, I believe that from 2006, all reports for non-police authorities were required to be submitted to the Crown Office and Procurator Fiscal Service electronically. I asked for that to be amended to, well, I actually say secondly, I believe the date I gave was likely incorrect. I now think it was from 2009 or 2010 and not 2006. From a document I received last week, it states that from the Crown Office and Procurator Fiscal Service that all specialist reporting agencies should, from 1st of January 2006, be reporting all cases electronically to the Procurator Fiscal. So it was to change that back again. And paragraph 23 of the second request asked me what role I played in preparing the prosecution. This is for William Quorn. I stated the wording of the charge is similar to the wording used when you submit a charge via the SRA website, but I cannot recall with certainty if this is something I did. I can now say that the report would have been submitted via the SRA website. However, I cannot recall if it was myself that submitted it or Raymond Grant, who was my ex-colleague. And also in my first statement at paragraph 11, I recall that it was temporarily promoted to the role of investigation manager in 2000, and I recall I attended some training at that time. Having looked at my statement again, paragraph 69 to 71 described parts of my training in 2005. I would also have been trained on these parts in 2000.
Thank you, Mr. Daly. With those corrections made, are the contents of your statements true to the best of your knowledge and belief?
Yes, they are.
For the purposes of the transcript, the references for Mr. Daly's statements are WITN 089401000 and WITN 089402000. Mr. Daly, I will not be asking you about every aspect of the witness statements you have provided, which will be published on the inquiry's website in due course. I will instead be asking about certain specific issues which are addressed in them.
Yes.
Starting, please, with the roles you have held with the Post Office. You have been employed by the Post Office since 1979, is that right?
That's correct.
You started as a counter clerk.
Yes.
You have set out in your statement the various roles you held thereafter and up until 1997, and those roles included roles in the remittance unit, cash management and distribution, is that right?
That's correct.
In 1997, you joined the security team with the Post Office,
That's correct.
and you started in the security team in 1997 in a postal officer grade, is that
correct.
right?
Yes.
So you were not at that point involved in criminal investigations, is
No.
that right? Then there was a period in around 2000 when you were temporarily promoted to the role of investigation manager.
Yes.
Roughly how long were you in that temporary role? Can you recall?
I can't fully recall. Could have been any time between probably about 6 months, maybe more, maybe less. I can't recall.
And during that time, were you involved in conducting investigations?
Only as a second officer.
At that stage, your temporary role did not become a permanent one, is that right?
That's correct.
Is it right that you applied for a further temporary investigation manager role in 2004?
Yes.
And you were successful in obtaining that position?
Yes.
And on this occasion, after the 6-month temporary period came to an end, you were told your position was being made permanent, is that
That's
right?
correct.
And this was in around 2005?
Yes.
You say in your statement at paragraph 4 that in 2011 your role changed to Security and Investigation Manager,
That's correct.
and your current role is that of Security Manager.
Yes.
Were these roles the same in substance, albeit different in title?
In substance, in the 2011, I believe it was, we took on the role of the physical security as well, and that was visiting branches after robberies or burglaries or to give security advice.
I would like to turn, please, to the structure of the security team over the time you have worked within it. You say in your statement at paragraph 33 that when you joined the security team, there was a head of security and investigations.
Yes.
And that head of security and investigations oversaw the investigation team,
Yes.
the security team,
Yes.
the physical security team,
Yes.
and the casework team.
I believe so.
At this stage, the investigation team dealt solely with criminal investigations and had its own head of investigations. Is
That's
that
correct.
right? And you recall there being a restructure in 2008
Yes.
when a senior security manager position was introduced.
Yes.
Is it right that you recall the senior security manager reporting to the head of security
Yes.
and overseeing a number of teams within the security team?
Yes.
Was it at this point that the fraud team was created in 2008?
The fraud team was always there. It was just what we were called the investigation managers or investigation team, I believe. Then we called it the fraud team. It was a name
It was a
change.
change in name.
Changing, yes.
And you recall the fraud team being responsible for undertaking investigations?
Yes.
Is it also right that when the restructure happened in 2008, you were required to submit your CV?
Yes.
Was that in essence you reapplying for your own job as an investigator?
Yes.
You have highlighted in your second statement that the CV you submitted in 2008 erroneously contained your wife's educational achievements. Is that right?
Yes.
Did you realise this and correct this at the time?
No.
So it's something that's only come to light in the course of preparing your second statement?
Yes.
At paragraph 35 of your statement, you say that in 2011, investigation managers also took on a physical security role as well as their investigation role.
Yes.
That's what you were referring to earlier when there
Yes.
was the title change.
Yes.
You recall there being further restructures in 2004 to 2005 and in 2009.
Yeah.
2019.
Yes.
Do you recall the various restructuring exercises also involving headcount reductions?
I don't recall.
I'm sorry, could you say that
Sorry.
again with your voice up a little?
I don't recall.
Do you recall any of the restructuring exercises impacting on the workload of investigators?
In 2019,
There were a number you dealt with, 2008, 2011, 2014 to 15 and 2019. In relation to any of those, do you recall that impacting upon the workload of investigators?
the investigations are stopped by 2019. That was the only time. 2014 and the other dates, no, there was no impact.
In terms of the geographical structure of the security team and where you sat within it, you say at paragraph 10 of your first statement that you have been based in Glasgow throughout the time you have held roles in the security team. Is that right?
That's correct.
Does that include the period from 1997 until you took up a permanent investigator role in 2005?
That's correct.
When you held a temporary investigator role in 2000, were you at that stage investigating matters both in England and in Scotland?
No, just Scotland.
And
Is
so
it,
do I take it, just so that I'm clear from the start, Mr. Daly, that the structure of the security team which you've described relates to the structure over the whole of the United Kingdom? It wasn't confined to Scotland, your description, was it?
That's correct.
Thank you. Yeah.
is it right that since 2005 you have been part of the Security Operations North team?
Yes.
You have addressed in your statements, and I will be asking you in due course, about your involvement in the criminal investigation and prosecution of two individuals, Peter Holmes and William Quam. Mr. Holmes's post office branch was based in Newcastle, and Mr. Quam's post office branch was based in the Outer Hebrides in Scotland. Both of these investigations commenced in 2008. Since 2005, have you been conducting investigations into matters both in England and in Scotland?
Yes.
And in terms of the geographical remit of the Security Operations North team, does that cover the north of England as well as Scotland?
It did, yes.
Can you help with a little bit more detail on which parts of the north of England came within your remit or come within your remit?
I believe it was Cumbria and over to Newcastle. And upwards.
I'd like to turn, please, to the decision-making process for criminal investigation and prosecution of sub-postmasters, their assistants and managers, and post office employed branch staff in England and Wales on the one hand, and Scotland on the other. Could we have on screen, please, paragraph 136 of Mr. Daly's first witness statement? That is page 36 of WITN 089-40100. And at paragraph 136, you say this: the conduct of investigations in Scotland was similar to England and Wales. The key difference was in the prosecution of cases. As I have described elsewhere in this statement, the prosecuting authority in Scotland is the COPFS. That's the Crown Office Procurator Fiscal Service. Is that right?
That's correct.
All cases, whether they be police or non-police cases, have to be submitted to the COPFS, who then decide whether to proceed to prosecution or not. In around 2006, it became a requirement that non-police authorities had to report cases through the COPFS Specialist Reporting Agency website. On inputting a case, you had to input a charge to proceed to submission. So that's the date that you addressed in correcting your second statement at the outset.
That's correct, yeah.
So you believe that that date is in fact correct?
Yes.
In relation to how cases were submitted to the Crown Office and Procurator Fiscal Service, before the change in 2006, how did that happen?
It was a manual report. You had to do a typed report that was similar to the offender report that was then delivered to the Procurator Fiscal either by post or by hand.
You deal with the process followed by post office investigators for criminal investigations at paragraph 59 of your first statement. Could we have that on screen, please? It's page 17. And at paragraph 59, you say that you have considered 3 versions of the conduct of criminal investigations policy from 2013, 2014 and 2018. You refer to a flowchart from the first two of those versions, and you use that to explain the process how the process worked in England and Wales and in Scotland.
Yes.
Could we have on screen alongside Mr. Daly's statement, if that's possible at all? POL 000310005. We can see that this is the August 2013 version of the Post Office Conduct of Criminal Investigations policy. Going to the bottom of page 2, please. We see the start of the, scrolling down a little more, please. We see the start of the flowchart you refer to in your statement. It provides, on the left-hand side, a number of sources of a case being raised, including an audit shortage, the Grapevine team. Can you help with which team that was?
The Grapevine team, they were our alarm receiving centre, but to start with, and dealt with any suspicious incidents at post offices. Post offices were encouraged to phone them up so we could send out a text blast. In regards to information, in regards to inquiries, I can't recall what they would have provided to us.
Also listed as a source are contract managers and client, e.g. DVLA, DWP. Going over the page, please, to page 3 of this document. Looking down the stage, we can see a number of steps on the flowchart for process. Case assigned to security manager. Is there evidence to proceed? If the answer is no, then no further action, case to be closed. If yes, interview and compile evidence. The next step is case preparation. Phase 1 MG format. Then the next stage is team leader to review the case file, proceed with the case, ? If it's no, then it's case closure. Further action could be further inquiries to be made, file returned to team leader. If it is yes, then it goes to the criminal law team to review the case file. Proceed with case ? No, then it's no further action. Further action required. There could be further inquiries made, file returned to the criminal law team and team leader informed. If yes, then it goes on to Cartwright King to produce the charges. Is it your evidence that the process in place up to the point of the criminal law team, so stopping short of going to Cartwright King, that was essentially the same for Scotland as it was for England and Wales until the introduction of a firm of Scottish solicitors into the process for Scotland in 2013?
Yes.
In a Scottish case, before this change, so before the introduction of a Scottish firm of solicitors, you say that a decision was returned to you by the criminal law team. So this is in paragraph 59 of your statement, we see alongside. If the decision was to proceed with prosecution, you would submit the file to the Crown Office and Procurator Fiscal Service, is that right?
That's correct.
If the decision was not to proceed, then the case would be closed.
That's correct.
This document shows the process in place in 2013, up to the point of the flowchart where there is consideration of a case by the criminal law team and not beyond that. Was the process any different from 2005 to 2013?
With the exception of Cartwright King, involved later on. I don't know when Cartwright King became involved, but yeah, essentially
Stopping
yes.
short of Cartwright King and stopping at the stage of it being referred to the criminal law team
Yes.
and a decision being made by them as to proceeding. Was this, the process we've looked at in this flowchart, the same between 2005 and 2013, or did it differ in any material way?
From what I recall, it was the same.
Before we turn to the introduction of Scottish solicitors into the process for Scottish cases in 2013 and the reasons for that, I'd like to deal, please, with the training you had for your role as a post office investigator.
Yeah.
That document can come down, thank you. In terms of your experience when you first took up a temporary investigation role in 2000, did you have any experience of criminal investigation or criminal law, whether in England and Wales or Scotland, at that point?
No.
Could we have on screen, please, paragraph 11 of Mr. Daly's first statement? That is page 5. At paragraph 11, you recall attending some training when you were temporarily promoted in 2000. Given the correction you made at the outset of your evidence, should we understand that the following paragraph, which deals with training you received on taking up the role of investigation manager in 2005, the training detailed there, was also received in 2000, or was it some lesser version of that training?
It was a lesser version of the training. There was parts I can't recall in 2000, the regulation of investigative powers, the II mark, or the NPA notifications. The NPA, the non-police agency, we only dealt with Scottish cases in 2000, so the team did.
Looking then to the training you received in 2005 at paragraph 12 here, you say, I recall that when taking up the role of investigation manager, I received 4 to 5 weeks training in the training unit above the Lavender Hill Post Office Battersea Delivery Office in London. The training was given by Royal Mail Group accredited trainers who had experience of investigations. The training covered the Police and Criminal Evidence Act 1984, Codes of Practice, Theft Act, carrying out searches, suspect offender interviews, cognitive witness interviews, taking witness statements, including the use of the solicitor and friends forms, the Regulation of Investigatory Powers Act, IMARC, which you explain in brackets here, refers to information, intention, method, administration, risk assessment, communications, human rights and other legal issues, and NPA notifications, NPA referring to a non-police agency, and the notifications refer to notifications we made to the police about the criminal proceedings we undertook. It appears from the list of topics here that this training focused on investigation in England and Wales. Is that right?
Yes.
Before we turn to the training you received on investigations in Scotland, I'd like to deal, please, with some of the detail of your initial training on lines of inquiry and disclosure obligations in England and Wales. Could we have on screen, please, page 20 of this statement, paragraph 72. And at paragraph 72, you say this: regarding the investigator's duties in carrying out investigations, I recall during the initial training that we were taught to ensure all evidence is obtained, lines of inquiries are completed, mitigating circumstances are considered and investigated, and interviews are conducted within guidelines. All activities taken were to be recorded on the event log. Were you aware from your initial investigator training that there was an obligation on a criminal investigator to pursue lines of inquiry which pointed away from the guilt of the suspect?
Yes.
You go on at paragraph 73 to say this: regarding obtaining evidence in the course of an investigation, also during initial training we were taught that the investigator must obtain all original documents. For example, in the event of an audit shortage, audit cash sheets, Horizon reports printed at the time of the audit, branch trading statements, and Horizon reports produced by the branch. The documents to which you refer here, are they the ones you would obtain as an investigator at a branch where an audit of the branch had discovered an apparent shortfall?
Yes.
You go on at paragraph 74 to deal with obtaining evidence from third parties. And you say this: the initial training also taught us about obtaining evidence from third parties who might hold relevant evidence. For example, bank statements, if it was suspected a shortfall was due to the monies being deposited into a suspect's bank account using Horizon. Also, ARQ requests to Fujitsu in order to obtain Horizon data in various cases. For example, to investigate deposits into bank accounts in post office card account cases involving a vulnerable person duped into making multiple withdrawals. When you were an investigator, were you aware that the obligation to pursue lines of inquiry, pointing away from as well as towards the guilt of a suspect, extended to material in the hands of a third party, for example, Fujitsu?
Yes.
At paragraph 75, you deal with training on disclosure obligations, and you say this: regarding an investigator's disclosure obligations, the initial training taught us that in England, it is the duty of the investigator, I think that should be to provide a record of all information obtained and to disclose all relevant information to the prosecution and defence. Pausing there, you repeat the second part of this explanation of an investigator's disclosure obligations, that is, to disclose all relevant material to the prosecution and defence, at paragraph 117 of your first statement, in the context of disclosure obligations on you in the prosecution of Peter Holmes. You have, however, made a correction to this in your second statement at paragraph 2.8. Is it right that you now recall that the disclosure obligation on a post office investigator in England and Wales was to provide all appropriate material, used and unused, to the criminal law team, who would deal with onwards disclosure to the defence?
That's correct.
You have dealt with the need to complete schedules of used and unused material as an investigator in England and Wales at paragraph 29 of your first statement. Did you understand from your initial training that when you were an investigator completing disclosure documentation in England and Wales, you were acting as the disclosure officer in the case?
Yes.
Did you understand from your initial training that this was a distinct role over and above your role as an investigator, which imposed on you additional and distinct duties, such as, for example, the obligation to draw material to the attention of the prosecutor where there was any doubt as to whether that might undermine the prosecution case or might reasonably be expected to assist the defence disclosed by the accused?
I would have.
I'm sorry, can you repeat that?
I would have.
Could we have on screen, please, document reference POL 001 21680? The top email on this page is an email from Andrew Daly to you, among other investigators, dated the 6th of September 2010. It forwards on an email chain with the subject line committal papers, asking whether there is any interest in a presentation from a Royal Mail Investigation Procedures and Standards Manager called Mick Matthews in relation to procedures and standards applying to committal papers. So if we can scroll down a little. Mick Matthews' email at the bottom of the page, also dated the 6th of September 2010, was originally sent to Ian Murphy and Andy Hayward. And he says, Ian, Andy, I have developed procedures and standards in respect of committal papers, and this has been agreed by the criminal law team. Accordingly, the P&S and the relevant forms are associated with this email. Arrangements are in hand to publish the documents on SharePoint and the GSD. A presentation has been delivered to RML, is that Royal Mail Letters?
Yes.
And PFWW, Parcel Force Worldwide?
Yes.
Investigators, as they do not get the same number of committals as investigators in Post Office Limited. So you may wish to merely forward this to your investigators for their information in respect of the procedures and amended forms. You address this email and the documents which were attached to it at paragraph 78 of your first statement. We needn't pull it up on screen unless you'd like to go to it, Mr. Daly, but you say that you cannot recall exactly when you received the materials attached to Mick Matthews' original email, but your belief is that this would have been the first occasion on which you saw those materials.
The materials within his zip file, yes.
The materials to which you were referred for the purposes of making your statement, the attachments to the email, included a new procedures and standards document relating to committal papers dated July 2010, an updated version of a procedures and standards document dealing with disclosure of unused material, and the Criminal Procedure and Investigations Act 1996, and that was dated the 1st of July 2010. And it also attached a copy of the Criminal Procedure and Investigations Act 1996 Code of Practice. Just to clarify, is it your evidence at paragraph 78 of your statement that you had not received any of these documents, including a copy of the CPIA Code of Practice, before this point in September 2010?
Sorry, can I see paragraph 78 again?
If we can pull up the paragraph on screen, it's paragraph 78 of the first statement, and that is page 21. Scrolling down a little, please. At paragraph 77, you refer to the document we've just looked at, the email from Andrew Daly dated the 6th of September 2010, together with its attachments, and there are 4 attachments there. 3 of those are ones that I've just referred to. One of them is the CPIA Code of Practice, and we can go to that document if it would help to see it. Would that assist, or do you know the document I'm referring to? If we can just take the attachments in turn, actually, the first is POL 001 04837. And that is the procedures and standards document which Mick Matthews refers to creating, the committal and summary trial papers and processes, July 2010. The next attachment was POL 001 04848. This is the
Yeah.
Appendix 1 to PNS 9.5, Disclosure of Unused Material and the Criminal Procedure and Investigations Act 1996, and that version is dated the 1st of July 2010. The next attachment is POL 000 64059. And that is the CPIA Code of Practice. If you need to, we can look at the next page. Scrolling down a little, please.
Yeah, that's fine. Can I go back to paragraph 78 again, please?
Yes, of course.
Can I see
So
the whole?
paragraph 78 of the statement. Page 21, please. So looking first at 77. You've looked at the
Yeah.
email and those attachments that we've just looked at, the first three.
Yeah. Can I
And you
see
say, you're asked where I was based when I received this email, whether this was the first time I'd been sent these materials, and if any presentation about them was given. And then you say at 78, the documents relate to some procedures and standards that had been developed in relation to committal papers. At the time I received the email at document,
Yeah.
and there's document reference, I was based in Scotland. I can't recall exactly when I received the materials, but it is my belief that this would have been the first occasion on which I saw them. And we'll come on to the presentation and your recollection on that. But my question is in relation to the attachment that is the Code of Practice, and whether that is in the same category as the procedure and standards documents, in that you received it for the first time at this stage, or whether you had received that document any sooner.
I can't recall receiving it before then.
Okay. You also say at paragraph 78 that you cannot recall receiving the presentation referred to in the email. Do you mean by that the presentation that Mick Matthews was offering?
Yes.
Do you recall any discussion as to whether that kind of presentation might be useful for investigators in the post
recall.
office?
Sorry, I don't recall any discussion around it.
Okay. When you took up the permanent investigator role in 2005, were you given any training on the Horizon system?
I don't recall any training on Horizon system. I do recall, I think, when I was temporary in 2000, we went to a hotel for a day to look at the system. What that covered, I can't remember.
And you say to look at the system. What do you mean by
we
that?
We were put in front of terminals, and it was in a hotel. I think it was a Swallow Hotel in Glasgow, as it was known at that time. I'm not sure what it covered, to be honest with you.
Did you receive any other training on the Horizon system apart from that training in the hotel in 2000?
I don't recall receiving any other training.
Did you ever receive any training on analysis of the data from the Horizon system?
No.
You say in your statement at paragraph 31 that during an investigation you liaised mainly with contract managers, the former agent debt team and cash management. Is that right?
Yes.
Were you given any guidance in your training on which other teams within the post office you should speak to to gather evidence in a case where the Horizon system had shown an apparent shortfall?
Not that I recall.
Were you made aware that product and branch accounting or information security might have relevant information relating to the operation of the Horizon system?
Sorry, could you repeat the question, please?
So there are two specific teams that I'm asking about, product and branch accounting and information security. And I'm asking if you were ever made aware that they might have relevant information when you were looking at the Horizon system and shortfalls shown by it.
Now that you've mentioned it, I probably would have been at the time. I was right when I wrote the statement. It's what I could recall at that point in time when I was writing it.
Turning then, please, to training you received on investigations and prosecutions in Scotland. Could we have page 6 of the statement on screen at the moment, please? And if we can actually go back to the bottom of the previous page. After dealing with the 4 to 5 weeks training you received, you say after a few months in my role as an... Going over the page, please. Investigations manager, I went to Rugby to attend further training, including courtroom training. And in the next paragraph after this, you say at paragraph 13, I can also recall being given on-site / field training on Scots law, with the main difference at the time being that in Scotland, a suspect was not offered a solicitor to be present at an interview. When did you receive this on-site or field training on Scots law?
When I joined the team after my training.
So in 2005.
Yes.
What format did that training take?
It was sitting with fellow investigators and going out to do investigations primarily as a second officer. When I say Scots law, I probably should correct that and say the Scottish way of dealing with cases in Scotland.
So was this in essence on-the-job training?
Yes, it was.
And who provided it?
My colleagues within the investigation team in the North.
Can you recall who that was now?
It would have been Raymond Grant, Shirley Stockdale. They'd have been mentoring me.
And how long did this on-the-job training last?
Sorry, I'm trying to recall it. I honestly can't recall how long it lasted. I went out and done a few probably second officer interviews and then been thrown in the deep end, been mentored doing first officer and conducting interviews.
The main takeaway point for you appears to have been that at the time in Scotland, a suspect was not offered a solicitor to be present in interview, and that's something which you address elsewhere in your statement, and you say changed in 2010 following the decision in Cadder and Her Majesty's Advocate. Is that right?
That's correct.
Setting aside procedural safeguards for interview, did your on-the-job training cover the offences under Scottish law which might be relevant where the Horizon system showed an apparent shortfall in a branch?
I don't recall that being the case.
It may follow. Does that mean it didn't cover the elements of any such offences which the prosecution would be required to prove?
That's correct.
Turning then, please, to the training on disclosure obligations which were applicable in Scotland. Could we have on screen, please, page 21 of the statement we have on screen? At the top of the page here, which is a continuation of paragraph 75 from the previous page, you say this: I learned on taking up my role in Scotland that it is the duty of the investigator to do the same as in England, with the exception information is provided to the COPFS. The COPFS considers whether the information meets the disclosure test before disclosing the information. I attended some training on disclosure provided by, and there seems to be a gap there. Did you mean to say by an organisation? We'll come to the document in a moment, so that may help you.
Attend some training disclosure provided by and have located. Yeah, the disclosure would have been in relation to the presentation from the Crown Office and Procurator Fiscal Service.
Could we have on screen, and you say I have located a copy of the presentation that was given, which I exhibit to my statement.
That's correct.
Could we have on screen, please, the presentation to which you are referring, that reference POL 001 29134, please? The inquiry understands this document to date to May 2009. Can you help with whether that is correct?
I think you mentioned the date further on, but I can't recall what date it was.
It appears to be a PowerPoint presentation produced by Kirsty McGowan from the Policy Division, Crown Office. Was this training the first training you underwent which dealt specifically with disclosure obligations in Scotland?
Yes, I believe so.
And in terms of dates, can you recall how long after you took up your permanent role in 2005 you went on this training? As I say, in fairness to you, the inquiry understands that this dates to May 2009.
If I put it into context, if this is the presentation I received in 2009, I would have been aware of disclosures to the Procurator Fiscal before that with my on-the-job training.
So you were given some on-the-job training, you say, in relation to disclosure obligations by your colleagues in the team who were mentoring you before this. Is that what you're saying?
In a roundabout way, we wouldn't sit down and say this is disclosure training. It's as the job went on and you had to just, when you were producing your productions, as we call it in Scotland, it's exhibits in England, that you're providing them to the Procurator Fiscal. And I don't think anybody really mentioned disclosure that I can recall. It was just something I learned to do. And then it was covered by disclosure. I know it was disclosure, but we didn't sit down and say, let's do disclosure training to the Procurator Fiscal.
Going to page 5 of this document, please. This sets out what the SRA, so Specialist Reporting Agency, and the Post Office was a specialist reporting agency at the times you were involved in. Is that right?
Yes, sorry, that's correct.
Record all relevant information obtained, provide the Crown with all relevant information, pursue all reasonable lines of inquiry. And on page 9, please, the consequences of non-disclosure are set out. Unnecessary trials, unnecessary delays, and in big, bold capital letters, miscarriages of justice. Do you recall this training now?
I recalled attending, it was Tully Allen, which was a police college. If you'd asked me to recollect the document without digging it out on the computer, I wouldn't have recollected it, but reading it, yes, I recall the training.
You also refer in your first statement at paragraph 80 to a specialist reporting agency's disclosure course run by the Scottish Police College, which you attended on the 20th of October 2010. Just to clarify, is that the same training as the training that is the subject of these slides, or was that a separate training event?
No, sorry, when you say this was produced in 2009, I thought that was a training you were talking about in 2010.
Well, my question for you, you refer to two different things in your statement. One, the training you say you went on and you've discovered the document here in relation to, and in a separate paragraph, and perhaps we can go to it, it's paragraph 80 of the statement. That's page 22, please. And at paragraph, scrolling up a little, please, paragraph 79, you refer to an email from the 5th of October 2010 and an attachment which was joining instructions, which we'll come on to. And you explain, you detail the circumstances where you were due to attend the Specialist Reporting Agency's disclosure course.
Yeah.
And you say at the following paragraph, I believe I was asked to attend the training as I was the investigation manager covering Scotland, being based in Scotland at that time. I recall that I did attend on the 20th of October 2010. So trying to clarify whether you attended one lot of training on disclosure or two, the PowerPoint presentation we've just looked at with the big, bold miscarriages of justice, was that a separate training event to this one being discussed here, or the same one?
The same one.
Okay. Could we have on screen, please, the materials which were provided by email ahead of the course you attended on the 20th of October 2010? Apologies, you need a reference for that. POL 001 29145. And so we have the date here, the 20th of October 2010, Specialist Reporting Agency's Disclosure Module Joining Instructions. And so just to be clear, the PowerPoint presentation we were looking at before, do you think that is one that was shown on this course on the 20th of October 2010?
Yes.
And so that was the first time on the 20th of October 2010 that you received formal training on disclosure obligations in Scotland?
Yes.
Is that right? Okay. There is a page providing background to the course on page 9 of this document, please. And this refers to Lord Coulsfield's report on disclosure, dated the 12th of September 2007. And it says, the four paragraphs down, Lord Coulsfield's report was published on the 12th of September 2007. The report forms the basis for the current Criminal Justice and Licensing Bill 2008, which will create legislation dealing with disclosure, which will be enacted in late 2010. And then over the page, please. Scrolling down a little so we can see the whole page. This deals with the common law duty of disclosure. And it says at the top, it must be stressed that disclosure or the principles of disclosure are not a new concept. The principles currently exist in common law and have been emphasised in various stated cases and court decisions. And then the case of Smith and HMA is referred to. And the quote has in bold this: "It is their duty to put before the Procurator Fiscal everything which may be relevant and material to the issue of whether the suspected party is innocent or guilty. We repeat, it is not for the police to decide what is relevant and material, but to give all the information which may be relevant and material." And then it says this: "The above decision quite clearly and concisely outlines the duties of the police in criminal investigations. However, since that judgment, a number of specialist reporting agencies now conduct their own investigations and report directly to the Crown, and the common law duty placed upon the police equally apply to SRAs." Do you recall reading that joining instructions material ahead of the course?
Not at the time, but I have recently pulled it back out and read that.
Would you have read it ahead of the course?
I would have.
In advance of the training session in October 2010, were you ever provided by the Post Office or by the Crown Office and Procurator Fiscal Service with the Crown Office Guide for Specialist Reporting Agencies, dated 2006? I think a copy of this has been quite recently provided to you by the inquiry. Do you know the document I'm referring to?
I don't. If you could remind me of it, please.
The reference is WITN 105 10102. This is the document to which I was referring. Crown Office publication, Reports to the Procurator Fiscal, a guide for specialist reporting agencies, 7th edition.
I would have received that, yes.
Can you recall who you would have received that from? Was it the Post Office or the Crown Office?
I think it was the Crown Office.
Sir, I wonder if that might be a convenient moment for our morning break, please.
Yes, of course. So what time shall we start? I'm
25 to, sir?
25 to. I mistakenly took myself off screen instead of unmuting myself, but we've got there, Mrs. Price.
Thank you, sir.
Right, 25 to.
Hello, sir.
Hello.
Can you see and hear us?
I think so.
Mr. Daly, in terms of differences in the procedure governing investigations in England and Wales on the one hand and Scotland on the other, you identify a number of these in your statements. In addition to the difference relating to the presence of a solicitor in interview, which we've already touched on, you raise the following in your witness statements. First, you deal with at paragraph 29, and if we could have that on screen, please. That's page 9. And at paragraph 29, you say, regarding disclosure, my role involved disclosing information to solicitors representing suspects prior to an interview. As part of the prosecution process in England, I would be required to complete the documents of the type at, and you give 2 references. Those are disclosure schedules, aren't they?
That's correct.
And other disclosure forms. These forms are not required in Scotland. So this is the first additional difference that you refer to. What was required in Scotland if those schedules of disclosure were not?
I can't recall if there were any.
The second additional difference that you raise is at paragraph 139 of your statement. And if we can have that on screen, please. That's page 37. You say at 139, another difference is that in England we are only required to summarise the tape transcripts from an interview, while in Scotland we are required to type out the full tape transcripts from an interview. So that's another difference that you're highlighting in your statement.
That's correct.
And third, you refer to evidential requirements. And this is at paragraph 137. So back 1 page, please, towards the bottom. And here you say the process also differed in that in Scotland, corroboration of evidence is required. You need to have 2 separate sources of evidence. For example, if a person transacts a deposit into their bank account using Horizon without putting the money in the drawer, the 2 sources of evidence could be drawn from the Horizon data, bank statements, CCTV, or witness evidence. On this last difference, how did the requirement for corroboration of evidence under Scots law affect the investigations that you carried out in Scotland?
Sorry, could you repeat that, please?
You've discussed at this paragraph the requirement for 2 sources of evidence, so corroborative evidence. How did this requirement in Scotland impact upon the investigations you carried out in Scotland as opposed to those in England and Wales?
If you could only draw evidence from, for instance, the Horizon data, and there was no supporting evidence, then you couldn't proceed with a case.
Whereas in England and Wales, Horizon data alone would be sufficient, would it?
I believe so.
Turning please to the change in the process for investigations in Scotland to allow for the involvement of a Scottish firm of solicitors. Could we have on screen please paragraph 21 of the statement? That is page 7. And at paragraph 21 you say this: In my performance review for 2013-2014, at poll 0010545, I refer at pages 3 and 4 to some work I did to secure specialist legal advice for Scottish casework when Scottish cases were submitted to Poll Legal Services for review. It wasn't recognised within Poll Legal Services and it was recognised within Poll Legal Services and the security team that they weren't knowledgeable about Scots law. I was concerned that I wasn't receiving the same legal support, and I recall that I asked if Scottish solicitors could be sought to assist and advise on whether there was sufficient evidence to submit a file to COPFS. I was advised to identify a suitable firm, and after researching some candidates, I identified BTO LLP solicitors. I believed they would be best suited as they employed a number of former procurators fiscal and had an office in Glasgow. I recall that I informed Jarnell Singh in Poll Legal Services, and I believe he contacted them and made arrangements for them to advise me on Scottish cases. When you say that it was recognised by Post Office Legal Services that they weren't knowledgeable about Scots law, do you mean that there were no Scottish qualified lawyers within the criminal law team?
Correct.
Is it right, therefore, that prior to managing to gain approval for BTO solicitors to advise on Scottish cases would it have been 2013?
From that document, I believe it was.
The criminal law team was providing a decision on whether a case should be passed to the Crown Office and Procurator Fiscal Service without being qualified in Scottish law.
I believe so, yes.
Did that concern you at the time?
It did concern me more when I was on my own in Scotland from about end of 2008, 2009 possibly. I was only investigator, and I just felt as if at times I would pass a case down to the criminal law team and there wasn't a full understanding of Scots law. I did approach the subject prior to 2013, requesting if we can get anyone. It just wasn't forthcoming at that time. I can't recall the dates when I did that.
Can you recall how long before 2013 you raised that?
Possibly a couple of years. I can't be certain.
Can you recall who you raised it with?
It would be my line management first and foremost.
And who in particular was that?
It would, whoever was my line manager at that time, it may have been Andrew Daly, it may have been after him.
And when you did raise it, what was the response?
I can't recall what the response was, but we just didn't get a Scottish lawyers on board.
Did BTO's involvement have any impact upon the volume of recommendations to the Crown Office and Procurator Fiscal Service to prosecute?
As in, did it increase the number we sent for?
Either way, whether it increased or decreased.
It gave a more informed decision on whether it should go forward or not.
Do you consider that Post Office investigators in Scotland were not adequately supported prior to the appointment of BTO solicitors to advise in 2013?
Yes.
Turning please to your relationship with the Crown Office and Procurator Fiscal Service. Did you have a particular point of contact at the Crown Office and Procurator Fiscal Service?
No.
Were you ever asked, following submission of a case to the COPFS, to conduct further inquiries?
Yes.
What kind of further inquiries would you be asked to conduct?
There is some documents that I was provided with that would be able to detail that. I can't think at this moment in time. It may be latterly it was in regards to Horizon. One of the main things they asked was when was the money first taken, or when was it stolen, and you had to provide an answer with that, any information you could give.
So setting aside what happened after the second site report and just looking back previously to that, you've given those examples of dates on which money went missing. Are there any examples that you have for that earlier period about pinpointing dates other than those?
Sorry, could you repeat the question?
You've given the example of being asked about the specific date on which money went missing. Were there any other type of inquiries prior to second sites review from the Crown Office, Procurator Fiscal Service? And what type of inquiries were you asked to conduct?
I'm trying to recall specifically, because there's none that come to mind at this moment in time. They may request a further statement from someone, from a witness. That could be an example. In regards to a product, I can't think of anything at this moment in time.
Did they ever ask you to obtain audit data from Fujitsu prior to the point of second sites review?
I can't recall if they did or not.
Before the second site report, were you ever asked about the reliability of the Horizon system data in any cases you had submitted to the Crown Office and Procurator Fiscal Service?
I can't recall.
Did you observe any differences in how the criminal law team approached prosecutions when compared with the Crown Office and Procurator Fiscal Service?
Sorry, could I clarify?
Well, for example, in terms of the decision to prosecute, did you observe any differences in approach between the criminal law team in cases in England and Wales and the approach of the Crown Office and Procurator Fiscal Service in Scotland?
Sorry, my mind's going blank here. I don't think there was any differences in approach that I can think of. If any further evidence was required, then they approached ourselves in regards to that.
Did you observe any difference in terms of consideration of public interest factors?
Not that I'm aware of.
Did you observe any differences in terms of lines of inquiry to be pursued?
I would say the Procurator Fiscal was probably more direct because it didn't have an understanding of the workings of the Post Office.
Did you observe any differences in terms of approach to disclosure over and above the technical differences or in disclosure obligations?
Not that I'm aware of.
You say at paragraph 14 of your first statement that each year all managers within the Post Office have to complete a 6-month and annual performance and development review. You've been referred to your performance and development review for 2013 to 2014 by the inquiry, and you've commented on that in your statement. More recently, the inquiry has provided you with copies of one-to-one meetings with your line manager, Andrew Daly, from 2009. Have you had a chance to look through those 2009 and 2010 documents?
I did.
I'd like to look first to those one-to-one line manager meetings with Andrew Daly. Could we have on screen, please, POL 00333 This document relates to a meeting on the 9th of November 2009, covering the period of the last 3 months. Under update priorities met, it says that the following requirements or action points have been met. And under 1, taken over Raymond's X cases and have registered these via the SRA system, progressing towards PF, is that Procurator Fiscal?
It is, yes.
Prosecution. In the box below, there are some comments from Mr. Daly, which read as follows. Following my meeting with Robert, I found that he is a motivated member of the security team. He has taken over some difficult cases from Raymond. One case is fairly intricate and has taken to bring to fruition. None of Raymond's cases were reported to the PF, so Robert is under pressure to register them with the PF, brackets online, and progress them to the point of prosecution. He is doing very well processing the stagnant cases, and the fruits of his labour will show in the new year, although PF cases take ages to prosecute once it's handed over to the PF. Robert also has good ideas and is very motivated. Robert took the opportunity to liaise with the PF and established whether the PO fraud strand can assist them with a different type of report, etc. He is awaiting a date to meet with the PF. It is also clear that he has a good working relationship with his local CM, Brian Trotter. Pausing there, who was Brian Trotter?
He was the contracts manager for Scotland, along with Robert Finlay.
Mr. Daly goes on, Robert has at least double the amount of cases due to the volume of cases raised in Scotland and the size of Scotland. Robert is the only investigator in Scotland. This has placed him under some pressure, but he is coping well. Robert has such a good relationship with the CMs and other post office staff. These cases find their way to him once detected. I will get the rest of the team to also take on more workload in the Scottish region so that Robert is not overloaded. You have referred in your second statement to you and Raymond Grant being the only investigators in Scotland in 2008. Is that right?
Yes.
It appears that by this point, in November 2009, you were the only investigator in Scotland. Is that right?
Yes.
Why had none of Mr. Grant's cases been reported to the Procurator Fiscal? Can you recall?
I have no idea.
Did you review these cases before passing them to the Procurator Fiscal's office?
I can't recall what stage of the investigation those cases were at. They may have been ready just to be reported. They may not have. I can't recall.
And this point in time in November 2009 was before you had had the benefit of any advice from Scottish solicitors. Is that right?
That's correct.
Did you feel under pressure to refer these cases to the Procurator Fiscal, given the apparent backlog and the fact that you were the only investigator in Scotland?
I'm not sure how I felt at the time, to be honest with you. Yeah. I know, and I can't recall all the cases that were there or how many it was, I couldn't really say how I felt at the time.
Did you feel that the investigations team in Scotland was understaffed?
Yes,
Did this have an impact on the quality of your investigations?
I don't think so, no.
The next box at the bottom deals with progress against personal objectives, and the first column sets out the relevant objective. If we can go over the page, please. And going over one more page, please. To the top there, we can see an objective. Recovery of 40% of monies from investigations conducted to have a positive return rate against investigation element of team. And in the next column, which deals with progress since last meeting, it says, exceeding target, see Excel data attached. Is this a reference to recovery of monies from those who were prosecuted, whether by way of confiscation proceedings or civil recovery?
It may not just have been for prosecutions, it may have been those that weren't prosecuted.
Is it right that as an investigator you were set a target for recovery of monies from those who were investigated?
Yes,
Was your performance measured in part against your target?
not as a whole. When you investigate someone, you would ask if they were in a position to repay the money. Not everyone was. So it would have been part of the personal development review, but not as a whole.
If you had not met your target of recovery of 40% of monies from investigations conducted, would you have been marked down?
Not necessarily. It all depends on how you performed in the other parts of your objectives.
It appears from this document that you exceeded your target for this period. How was that rewarded, if at all, by the Post Office?
It wasn't. It was just part of my targets.
Going over the page, please. We can see the next box is review of behaviours action. And going over the page again, please. There seem to be some examples. Are these examples given by you?
Yes, they are.
And the third example says this: Earlston PO took on case from colleague, advised Procurator Fiscal on analysis of Horizon information. Unfortunately, she deemed insufficient evidence for theft. Discussed a charge of uttering. Can you help with what uttering is?
I couldn't tell you the legal term, but uttering is basically to produce something you know to be false.
As Postmaster had repaid £3,000, this was considered and accepted, awaiting outcome of plea from defence.
Yeah.
You were here providing an example of you analysing Horizon information. Can you help with what analysis you would have been doing?
I can't recall that. It may have been information that was already in the case file when I took it over. I don't recall doing any further work on that case file. I believe it was already with the Procurator Fiscal, and it may have been assistance the Procurator Fiscal was requesting in regarding the Horizon information disclosed.
Where you were doing analysis of Horizon information, were you analysing printouts from the branch, from the Horizon system, or audit data obtained from Fujitsu, or both?
I don't recall. I couldn't honestly tell you.
You appear here to have been dissatisfied with the Procurator Fiscal's decision that there was insufficient evidence of theft based on the Horizon data. Was this an issue that came up frequently in Scotland, that Horizon data alone would be deemed insufficient to prove theft?
I'm not too sure if that was just due to the Horizon information. That may not have been that. It may have been other evidence as well. I honestly could not say if that was just down to Horizon information. I don't recall.
I'm not trying to be too legalistic about this, but Horizon information alone would not be sufficient, would it, if there's a requirement for corroboration?
That's correct. If they were relying on Horizon and another piece of evidence, whatever that evidence was, and they felt the other piece was sufficient, but the Horizon wasn't, then they would consider that to be insufficient evidence, because it doesn't, one doesn't help the other. If you
No, there had to be two independent pieces of evidence, yeah?
yes,
No.
Mr. Daly, being aware of the need for corroborative evidence of Horizon data, were there still cases being put forward to the Crown Office and Procurator Fiscal Service relying solely on Horizon data?
when you say solely, as in the only
As
evidence?
in there was not corroborative evidence, there wasn't a second source. It would appear, the reason I ask Mr. Daly is it would appear on one reading of this that there was analysis of Horizon information that was put forward to the Procurator Fiscal's office, and it was deemed insufficient evidence for theft. So my question is, notwithstanding the need for two sources,
Yes.
were cases still being put forward with one source, Horizon data?
No, they wouldn't have been put forward with one source. You'd have put more than one production in regards to the, whether it was a theft or embezzlement. You would provide the productions to the Procurator Fiscal. The Procurator Fiscal, as with exhibits, would look at those productions, and if it was two of those independent sources were sufficient to proceed to a prosecution, he would take them forward. If there wasn't, then the case would be dropped. You wouldn't just be putting forward Horizon data itself on any case.
Could we have on screen, please, POL 00333 406? This is another one-to-one meeting record of a meeting between you and Mr. Daly, Andrew Daly. It relates to a meeting on the 4th of February 2010 by telephone relating to the previous 3 months. And Mr. Daly's comments are recorded in box 3 and read as follows. Robert remains one of the top investigators in the fraud strand. His keen attitude and commitment is exemplified in the prosecutions and especially the recovery of the loss, see spreadsheet. Robert is always willing to assist where he can, even if this means that he has to travel long distances or work long hours. He has a can-do attitude and looks at all the avenues in order to prosecute a case, but he is also mindful of the Scottish legal system and the various regional PF's idiosyncrasies. I am concerned that Robert is trying to do too much in Scotland and get bogged down. If a wave of Scottish cases arrive, brackets New Horizon roll out findings, these will need to be allocated to other investigators who must attend to them without Robert assisting, brackets taking statements, etc. Otherwise, he will just get bogged down with their work. The reference here to you looking at all avenues to prosecute a case. You say in your statement your first statement at paragraph 64 that you played no role in relation to prosecution decision making. It might appear from that comment that you were actively trying to secure prosecution decisions from the COP, from the Crown Office and Procurator Fiscal Service. Is that right?
No, that's not correct at all. I can see how that looks, but I'm not sure why my line manager at the time, Andrew Daly, wrote it that way, because all I can do is take a case, look at all the evidence, and if there's sufficient evidence at that time to put it forward to the Procurator Fiscal, that's what I did. And it's the Procurator Fiscal. You can't persuade a Procurator Fiscal to prosecute. They make that decision independently.
Can you help with why you needed to be mindful of the Scottish legal system and the various regional Procurator Fiscals' idiosyncrasies?
I'm not sure why you wrote that either. I don't understand what you was talking about.
Does the reference to the new Horizon rollout here refer to the rollout of Horizon Online?
I believe it would have been, if that's when it was rolled out in 2010.
Was it expected that there would be a wave of cases following its rollout?
They were sending not just auditors, I think it was trainers, in to do cash checks prior to Horizon Online going in. If from what I recall, they thought there may be a lot of cash shortages identified when this was getting done.
Could we have on screen, please, POL 001 05025? This document is the individualised objectives for security team members for 2013 to 2014. The objectives for you are set out on pages 128 to 129. Could we go to page 128, please? We can see your name and the first two boxes on this page refer to core behaviours. Just scrolling down, please. Then over to the next page. The third objective is to ensure a robust approach to fraud loss recovery with a return rate of 65%. Activity to include: ensure that evidence opportunities are maximised through stakeholder engagement, technical elements of inquiries are effectively deployed, searches of persons' premises, ensuring full engagement with FIs, is that financial investigators?
It is, yes.
And police contacts, optimising POCA powers to achieve maximum possible recovery, e.g. monetary recovery, asset recognition. Ensure all intervention measures are adopted to recover stolen funds. It appears here that the target for loss recovery has increased since the 2009 one-to-one meeting record we looked at. Then you were over target at 40%, and here the objective is 65%. Is that right, that the target was increased by the Post Office?
I believe that target was increased after I was sent to document my objectives for 2000, I can't remember if it was 12 to 14 or 11 to 12. and it was the same figure of 65% on it. It was increased at some point, yes.
Why was it increased?
I can only think it was because of the amount of losses the post office was suffering.
Was this target indicative of the recovery of funds from those being investigated being a high priority within the post office?
Sorry, can you clarify what you mean there?
This target and the fact that it had been increased,
Yes.
is that indicative that the recovery of funds from those being investigated was a high priority within the post office?
It was never looked upon as that when we received our targets or objectives, but it would suggest it was.
Was this a target set for all post office investigators?
Yes.
It was a target you were aware of because it was part of your performance objectives.
Yes.
Do you think this ever influenced the conduct of investigations you were charged with?
No.
Could we have on screen, please, POL 001 05145? This is a record of your one-to-one performance review with Helen Dickinson for the year 2013 to 14. If we can go over the page, please. We see reviewee you and review owner Helen Dickinson. Was the purpose of the performance review to review performance against the objectives which had been set?
Yes.
Could we go, please, to page 2 of this document? Well, we're on page 2, in fact, so about halfway down the page. And you say about halfway down, my PDR is completed to timescale.
Yes.
And then there's a hashtag 160. I have achieved an 86% recovery. Brackets, pounds, 68,733 in my cases. So it appears from this that you had exceeded your 65% target, is that right?
That's correct.
To repeat a question I asked before, how was meeting this objective at this stage rewarded by the post office?
I understand where this is coming from, where we've been given bonuses for recovering money. It was part of our objectives to do so. It didn't necessarily rely on a bonus. We received a bonus every year regardless.
The bonuses that were received, for whatever reason,
Yep.
were those individual bonuses or team bonuses?
No, there were individual bonuses in how you performed over a year, if you performed better than someone else. So technically you could say this went towards, but if you speak to individuals within the investigation team, the investigation managers, it was always considered an unfair target, because any inquiry you did, any case you did, all you could say to the person was you in a position to repay the money. If that person didn't have the money, you couldn't get blood out of a stone.
Could we go to page 4 of this document, please? About 2/3 of the way down the page is a heading, Financial Investigators. And under this heading, you say this: I have long recognised that a FI, Financial Investigator, is required for Scotland, as the Crown Office has now deemed that Police Scotland FI and, can you help with that, RS Quos?
It's unfortunately, it was a system we put it into when you printed it out. It, as you can see, with 160 plus hashtag.
Is that Police
That's a
Scotland
pound.
FIs?
It's FI and it's Police Scotland Financial Investigators, and there was another name. I can't recall what the name was, but it was just Police Scotland Financial Investigators.
So the Crown Office has now deemed that Police Scotland FIs are no longer to be used as a debt collecting agency for external business. I have set up and attended an initial meeting with Police Scotland and Post Office Limited FI, and then we have the same set of symbols. The meeting discussed how POL can access recovery from POCA through a complicated legal system. I am currently engaging with the Scottish Business Resilience Centre to ascertain if there are any agreed protocols concerning other government bodies utilising POCA powers. This is an issue that has never been progressed like the rest of the UK, and I am determined to progress this as far as possible to ensure POL Scotland have the same recovery procedures and support as in the rest of the UK. This continues to be a work in progress, and SBRC are making inquiries to assist POL. I have discussed with BTO solicitors regarding running a civil case alongside the criminal case to ensure POL are at the forefront of creditors. A draft is being worked on by BTO to be put to POL for consideration. I am taking all steps to ensure POL can recover funds from sub-postmasters. When you say the Crown Office had deemed that Police Scotland Financial Investigators were no longer to be used as a debt collecting agency for external business, does this mean that this is how Police Scotland Financial Investigators had been viewed, at least by the Post Office prior to this?
I don't believe that's how they were viewed by the Post Office, and I don't think that was in regards to the Post Office, that statement coming out.
How did the Crown Office convey this stance to the Post Office?
I can't recall how it was conveyed.
What did you propose, insofar as you can recall, in relation to the use of POCA when you met with Police Scotland?
I think it was to ask them about their powers in the recovery of assets, or basically cash. And I'm sure that in Scotland you need to, and I could be wrong, a Section 3 and none of our financial investigators had a Section 3. I can't recall what was fully discussed, but I think it was along those lines.
You appear to attach significant importance to this issue in your performance review. Is that fair?
When you write a performance review, you're flowering things up to make it look good, in fairness. And when I said it was the main issue for me, it wasn't as such. What I did recognise was in England and Wales there was financial investigators making recoveries, and I took it with BTO solicitors, and it was another avenue to look at in regard to a civil case, and how we can recover any losses to the post office.
Was this issue something you understood to be of significant importance for senior managers within the security team?
Yes, if they were going to put a 65% recovery on it, then they had to view Scotland the same as everyone else.
You refer in your first statement to a financial evaluation form.
Yes.
Could we have paragraph 18 of Mr. Daly's first statement on screen, please? It is page 6 of the statement. At paragraph 18, you say this: in my CV, I mentioned the financial evaluation form. Following an interview with a suspect, I was required to complete a financial evaluation sheet. This detailed the suspect's name, the post office branch, and what they had said about the loss. The form also recorded my opinion on the loss and any financial details given by the suspect, including how they intended to repay any monies. Although I had to complete the form for Scottish cases, it was recognised that Pole financial investigators did not have the authority to conduct a financial investigation in Scotland. Was this form part of the strategy for recovery of monies from those being investigated?
Yes, it was.
Was the purpose of this form to assess the chances of recovery of monies?
Yes.
So this form, just to be clear, was not a way of trying to follow the money, so to speak, to establish whether, for example, theft had occurred.
No, the form itself was, to try and obtain information on what assets a suspect had, and it was passed to the financial investigators to then follow that through.
Just one more document on this topic, please. Could we have on screen, please, POL 000 57678. This is an email from Zoe Topsham to you, dated the 3rd of March 2012. Well, apologies, that may be the wrong way round, looking at the email below. I think that may be the 3rd of May. Scrolling up, please. 3rd of May to 2012. It forwards a link originally sent by Alison Bolsover to you, which appears, scrolling down, please, which appears to be a news article relating to the Seema Misra case, and it's www.getsurrey.co.uk/news, and the indication as to the title of the piece is Postmistress Who Stole 75,000 to Pay Back Just One. And then going back up, please, to Ms. Topsham's email to you. She says, one of my other cases, ! Something to cheer you up, ! What discussions had you had with Ms. Topsham about this case, about the Seema Misra case, if any?
I've no idea, because it wasn't my case. I can only think that we had to inform the former Regent State team if we'd got a recovery, from what I recall, and if I had informed her that on a case that we hadn't got a recovery, she may have just sent this to me because she wasn't getting any, they weren't getting any recovery from that one as well. Why Zoe sent it to me, I can't recall why she sent it, but the Misra case was not one of my cases.
Okay. Can you offer any insight into why she thought this was something that might cheer you up?
I think that was a sarcastic comment.
That document can come down now, thank you. Moving please to ARQ data requests. You say in your first statement at paragraph 19 that cases had to be submitted within appropriate timescales and that you believe this may have been 12 days from the interview of a suspect. Is that right?
Yes.
Was that the case for both England and Wales and Scotland?
Yes.
So by 12 days post-interview, you were expected to have filed your investigation report with the criminal law team, is that right?
You had to at least provide an interim report, if I recall, because you may not have conducted all your inquiries.
Is it fair to say you had limited time to conduct inquiries before you submitted at least an interim report?
Yes.
Did you ever request ARQ data from Fujitsu in an investigation before you submitted your interim or final investigation report to the criminal law team, i.e. within that 12-day time frame?
I may have. There may have been occasions when I didn't, and that was recorded in the interim report that had been requested. You would not have got the ARQ data back within 12 days from what I recall. So if there was any mention, it would be that you'd requested it.
In terms of the circumstances in which ARQ data was sought from Fujitsu, could we have on screen, please, paragraph 89 of Mr. Daly's first statement? It is page 24. At paragraph 89, you say this: paragraph 29 of the request asks ARQ data requested from Fujitsu as a matter of course when a shortfall had been identified and the relevant SPM's manager or assistants, Crown Office employee, attributed the shortfall to problems with Horizon. And in response to that question, you say ARQ data was not requested from Fujitsu as a matter of course. It would only have been requested if it was relevant to an inquiry. In what circumstances would ARQ data have been considered relevant to an inquiry?
It may have been in relation to what we call gyro suppression of someone's bank accounts. If it was suspected they were paying money into a bank account, or it could be a card account inquiry, where I tend to find it was elderly people. A member of the family had noted that there was money being taken from their account, and the person had approached the counter and was told the PIN wasn't working, and to put the PIN in again, and the postmaster was suspected of stealing the second amount. So you'd be looking for ARQ data to see and request the card details for that person's account, and that would tell you how many transactions were done out of that card account at a time.
Did you ever request ARQ data with the purpose of investigating a suggestion by a sub-postmaster, or assistant or manager, or an employee of the post office that the Horizon system was the cause of an apparent shortfall?
In relation to it just being the problem, I don't recall it just being in regards to that, because if they suggested it was a problem with Horizon, then it would be put into the report to be submitted up to the line manager and forwarded on, and I would expect that to be followed through by them with Fujitsu. The ARQ data would be, I can only think in relation to a product we may believe that money was paid into, or as I stated previously. Sorry, I should add to that, if someone had said it was Horizon data, we would have requested a statement from Fujitsu.
So the impression I'm getting, and correct it if I'm wrong, Mr. Daly, is you acting alone, so to speak, would request ARQ data where you thought it might support the prosecution case.
Yes, sir.
If the suggestion was that it might undermine it, you'd send it up the line. Is that it?
You would include it in the report, but you would, I would likely request a statement from Fujitsu
Right.
in regards to whether there was issues at that branch.
Mm-hmm.
That would go with that'd be requested through, along with the ARQ data at the time, sir.
Could we go over the page, please, to paragraph 92? In this paragraph, you are addressing an email in which you requested audit data from Fujitsu. And you say in this paragraph that you would only contact Fujitsu if it was specifically required for a case. Do you mean by this that you would only contact Fujitsu if you were asked to by someone else?
I recall, if I remember correctly, after viewing the documents, I'd received a statement from Andy Dunks from Fujitsu. I needed a signed copy of that statement, and I went direct to him only because I'd been copied in on an email with his details on it, and that was in relation just to getting a statement signed. I believe that's what that was. Otherwise, any request for Fujitsu, including statements, went through our post office security team, or the casework team, as it was.
I'd like to turn, please, to the investigation and prosecution of Peter Holmes. You deal with this case at paragraphs 97 to 132 of your statement. It's right, isn't it, that you interviewed Mr. Holmes following the identification of an apparent shortfall by an audit conducted in September 2008 at the post office branch which he managed?
Yes.
You also completed an investigation report, in fact, 2 investigation reports, an interim one and a final one,
Yes.
which were submitted to the criminal law team. And you completed a schedule of non-sensitive, unused material in the case, saying in your first statement to the inquiry that you were the disclosure officer in the case. Is that right?
That's correct.
Starting, please, with the interview of Mr. Holmes on the 19th of September 2008. Could we have the report of tape-recorded interview on screen, please? It is POL 000-50208. We can see on the face of this that the interview was on the 19th of September. The duration of the interview was 45 minutes. You were listed as the interviewing officer, and Christopher Knight was the second interviewing officer. Is that right?
That's correct.
Going to page 2, please. About halfway down the page, you asked about Mr. Holmes's experience with Horizon, and you say, and your experience with Horizon, how would you rate it? And Mr. Holmes's response was, very slow, it's okay, it's an auditor's tool. That particular one we had problems with because it was connected to a telephone line that also had the fax machine connected to it. And you ask, what one's that Jesmond? Answer, Jesmond, and we had BT engineers in looking at the line. We had Horizon engineers in looking at the line. And eventually we had to take the fax machine out, throw it away and get a new one in provided by Mr. Canna. And now, Mr. Canna was the sub-postmaster, is that right?
Yes.
And now it seemed to work, but there was a time there when it wasn't so slow, it wasn't so good. People using cards just weren't getting through. You ask, what period was that? The answer, I suppose, 9 months ago for 3 months. So we're talking about the beginning of this year, December. Yeah, I'm not very good with times, but yes, possibly. And then PH states that they had engineers coming on over a 3-month period. Over the page, please, towards the bottom, at 1450. We then have a summary. PH explains the computer program is really slow at the end of the day, taking up to 1.5 hours. He continued that Doreen leaves at about 6:30 p.m. with him staying until 7:30 p.m. And later in the interview, you ask Mr. Holmes about the apparent shortage found on audit of just over £46,000. It's page 8 of this document, please. Starting at 2604. And you ask, right, okay, well, the situation here then, Peter, that the audit have come in on the 18th of September 2008. Can you tell me what happened that morning? And Mr. Holmes says, yes, and they'll let me in, give me the keys. The auditors introduced themselves. I looked at their passes, went into the post office and let them have a go at it. And they found that there was 2 cash declarations made and one was well out. And at the end of the audit, 46,000 odd was missing. And you give the exact figure there. And he says, yeah. So what can you tell me about the shortage then? I've absolutely no idea. No idea. Absolutely no idea, unless it's the Horizon that's let us down. I mean, there's no one in there stolen 46,000. I haven't got it. It's not in my bank account. I spent too many years in the police force seeing things go wrong to start stealing money from anybody. I really do not know. And then you ask, why is there 2 cash declarations then? There was one in because I knew that we were showing short and I covered it up. Covered what up? The fact that we were short in cash. How much by? Not that much. I can't remember the exact figure. Roughly, it started off as 4,000 or 5,000. When was that? 6 or 9 months ago. When you said it started off 4,000 or 5,000, what did it creep up to? Well, it's now up to 40. It's up to 46,000 now. So Mr. Holmes was clear in saying that there had been problems with the Horizon system in the branch, necessitating the attendance of an engineer, hadn't he? The first part of the interview that we'd looked at.
Yes.
And he was suggesting here that the apparent shortfall might have been caused by the Horizon system, wasn't he?
Yes.
You deal with this at paragraph 98 of your first statement. Could we have that on screen, please? It's page 27 of the first statement. And at paragraph 98, you say this. Paragraph 38 of the request asks me if I was aware of any allegations made by Peter Holmes relating to the reliability of the Horizon IT system, and if so, what I thought the significance of this was. Mr. Holmes indicated during interview that the loss may be down to the Horizon system. At the time, I don't believe I would have been aware of the significance of this, as I don't recall being aware of any issues with Horizon at the time. Mr. Holmes said he couldn't explain the losses, and I didn't believe anyone else in the office had stolen the money. In terms of what you did to investigate the issues being raised by Mr. Holmes, we are assisted to some extent by an interim investigation report you completed in October 2008. Could we have that on screen, please? It's POL 000 50334. And if we could go to the second page of this document, please. It is only 2 pages, just scrolling down to the bottom. We can see the date there, the 6th of October 2008. And about halfway in the middle of this page, you deal with Mr. Holmes's account given an interview. And can we scroll up a little, please? And you say Mr. Holmes denied theft of the money, however admitted false accounting over a period of no less than 9 months. Horizon data has been requested to ascertain when Mr. Holmes started producing false cash declaration and subsequently false accounts. Mr. Holmes made allegations the Horizon equipment was faulty over a period of time in early 2008. A request has been made to ascertain if this was the case. These papers are submitted for the current position to be noted. So this was an interim investigation report, was it?
Yes.
Focusing on first on the request you say was made to ascertain whether the Horizon equipment was faulty. You revisit this in your final investigation report. Could we have that on screen, please? It's POL 000 508 50832. Going to page 8 of this document, please, which is the last page. We can see that it is dated the 30th of January 2009. Going back to page 3, please. And the last paragraph on this page. Scrolling down, please. Scrolling right the way down, please. Questions were put to Mr. Holmes regarding the figure of the loss there, shortage discovered at audit. Mr. Holmes said the auditors found that there were 2 cash declarations made and that one was around £46,000 out. Mr. Holmes stated he had no idea what happened to the money, adding it may have been the Horizon system. He further stated nobody in the office had stolen the £46,000. He then said he didn't have it, it wasn't in his bank account. He further said he had spent too many years in the police force seeing things go wrong to start stealing money from anyone. So you put into your investigation report, didn't you, the issues that were being raised by Mr. Holmes in relation to the system?
Yes.
And going please to page 7 of this document. The second line down, you say this: Mr. Holmes also made allegations the Horizon equipment was faulty over a period of time in early 2008. This has been checked and the allegations are unfounded. And Going further down the page, please, about 2/3 of the way down, Mr. Holmes has attempted to blame the Horizon system on the shortages. However, checks have revealed no problems. In relation to the checks that you refer to here, you address this at paragraph 104 of your first statement. Can we have that on screen, please? It's page 28. At paragraph 104, you say this. Paragraph 44 of the request asks me to consider my investigation reports. In particular, my report, that is the interim report, refers to a request being made to ascertain whether Horizon equipment at the Jesmond branch was faulty. I note that at your final report, at page 7, my report says that checks had revealed no problems with Horizon. I cannot recall what checks were carried out in relation to Horizon at the branch, who carried out the checks, or what the results were. I've considered all the documents and can't find anything in relation to the request or the results of the checks. As you note in your statement here, there is no record that the inquiry's been able to find to evidence any request for checks to be carried out, what any checks consisted of, or what the result of any of those checks were. No material was disclosed in the course of the prosecution of Mr. Holmes to show what checks were undertaken or how they were said to refute Mr. Holmes's concerns about the Horizon equipment. You completed the schedule of non-sensitive, unused material in Mr. Holmes' case. Could we have that on screen, please? It is POL 000 51527. And scrolling down to the bottom, please, we can see the date of this. The 19th of May 2009, as well as your name. If we can scroll up a little so that we can see the list of material here. Casting your eye down the list of material contained in this schedule, is there anything listed which you consider relates to the checks carried out to ascertain whether the Horizon equipment was faulty?
No.
Any such material would have been disclosable in these proceedings, wouldn't it?
Yes.
Would you accept the absence of such material being listed here reflects either a failure in the investigation, i.e. a failure to properly investigate the issues being raised by Mr. Holmes and have those checks carried out?
No, sorry.
Or a failure in disclosure on your part?
No, I can't say it does. As I stated in my second statement, there would have been a list of exhibits, and without that list of exhibits, I can't say for definite what was disclosed to the criminal law team. I would not have put those comments into the final report if I hadn't conducted them. I don't understand why there's no paperwork there in relation to them. I have asked for the green file jacket, which contained all the paperwork, and I've not been able to obtain that. That would at least give me some indication of what was requested and what the result of those checks were.
So that marks a break in subtopics under the case of Mr. Holmes. I wonder if it might be convenient to take an early lunch at that point until 10 to 2.
Yes, of course. So we'll break off for lunch until 10 to 2.
Thank you, sir.
Good morning, sir. Can you see and hear me?
Yes, I can, Mr. Beer. I understand that there's been a flurry of correspondence from those acting for the post office in relation to documentation, but that doesn't necessarily affect the questions you wish to put to Ms. Cotton. Is that correct, Mr. Beer?
Sir, that's right. We've been told by the Post Office's representatives that the recent discoveries that they have made do not reveal documents that concern Mrs. Elaine Cotton. And so, although we plan to discuss the recent revelations today, we would propose that we hear from Mrs. Cotton first and then deal with the disclosure issues.
Yeah, that sounds fine to me. So unless someone in the room is trying to attract my attention to say something different, that's what we'll do, Mr. Beer.
Thank you. Yes, nobody is saying otherwise.
Fine, thank you.
So may Mrs. Cotton swear or affirm, please?
Yes.
Good morning, Mrs. Cotton. Can you hear me clearly?
Yes, I can.
I'm going to take you through the affirmation. Would you repeat after me, please? I do solemnly,
I do solemnly,
sincerely and truly
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you very much. Mrs. Cotton, can you see and hear me?
Yes, I can.
Thank you very much. My name is Jason Beer and I ask questions on behalf of the inquiry. Can you please give us your full name?
My name is Elaine Mary Cotton.
Thank you very much for attending remotely to give evidence to the inquiry. We're very grateful. You should have in front of you a hard copy of your witness statement, which is 2.5 pages in length and dated the 31st of July 2023. Is that right?
It is.
And on the third page of it, is that your signature?
It is.
And are the contents of the witness statement true to the best of your knowledge and belief?
They are.
For the transcript, there's no need for the witness statement to be displayed. The URN is WITN 0953 0100. Mrs. Cotton, you were asked by the inquiry on the 12th of July 2023 to provide a witness statement, and accompanying that request was a large volume of documents that were relevant to the questions that we were asking of you, which documents dated from your time in the post office. And you've provided us, we've just established, with a witness statement that's 2.5 pages long, which contains next to no information. Is there a reason for that?
I don't know what sort of information you wanted me to put in it.
Well, by way of example, the first question we asked you was to set out your professional background. You've not answered that at all. Is there a reason for that?
No, it's just a misunderstanding. I can give you that now.
So I'm asking you why you didn't include it in your witness statement when we were asking you to.
I don't know. I can't remember being asked to do it, because I would have done it because I have it here.
The request of the 12th of July says, please set out your professional background. And you haven't. Why not?
It was just a misunderstanding. I didn't know how to do it because I actually have it here.
And what are you saying you have it here?
Well, I have it written down.
Your professional background?
Yeah, within the post office, yes.
So what was the nature of the misunderstanding? You receive a letter which says, please,
Which letter was it? Because I have everything
12th
on
of
my letters
July.
here, but
12th of July 2023, and it says, please set out your professional background. What was the nature of the misunderstanding? Between whom?
Well, but just between myself and what I was asked for. What date was the
What didn't you
letter?
understand when?
Well, if you can let me find the letter. What was the date of the letter, please?
12th of July 2023.
12th of July 2023 to August. Well, I've got everything in my file in order, and I don't have it. The first letter I've got is just about this bundle. I'm sorry, there was no intention to mislead, but I haven't got it. I'll just have a look in the. I've got 3 different files here. The one from Ashford's.
They're your solicitors.
All right, so we won't need that one. The other one's the same. That's just the same as this huge thing I've got here.
Okay, don't trouble yourself with the bundles. I'm telling you,
Yeah.
you were sent a letter on the 12th of July 2023, which led to this witness statement being created. The first question said, please set out a summary of your professional background. You appear to have ignored that. Why?
I've just put I was employed as a retail line manager at post office counters. I don't remember the date I took up this post or the date I left. I've put that I was responsible for 27 post offices. I have that here.
Is that a full and complete statement of your professional background?
With the post office, yes.
Does it say when you joined the post office?
No.
Does it say when you
This
left the
was
post
first-
office?
first of
Hold on.
Sorry.
It doesn't say when you joined the post office. It doesn't say when you left the post office. Why not?
No, because I didn't know that there was asked for. I've got that information here, and I would have included it if I'd have known that's what it was. I thought we were talking just about the retail line manager's job that I did. I didn't know it was from when I first joined the post office.
So when you received
No intention.
when you received a question that said, please set out your professional background, you understood that only to relate to your job as a retail line manager?
Yes, I did.
Why?
I've written the rest of it down because I thought I would be asked about it today, how I got to be this.
Okay, when did you join the post office?
1979, as a postal officer.
Which branch?
Cleveland's branch, but it was a directly controlled branch then. It wasn't a modified post office as it is now.
And what's the significance of that?
I was directly employed by the post office, not like with the modified office as a sub postmaster.
How long did you work at Cleveland's?
I worked there until 1981 when I transferred to Blackpool branch office as an assistant manager.
And what did you do in Blackpool branch office?
Well, I managed the staff that were there. It was basically the counter duties, making sure everybody was there on time, just general day-to-day working of the office to make sure there was enough cash for everybody, to make sure that everybody was balancing correctly, to make sure the counters were tidy, clean. I was the assistant manager, so the manager would have done a lot of the direct transferring of cash to them in the morning. I would have done a lot of checking their balance sheets, certainly with pension dockets that were then. I would sometimes I'd list all those for them to help them, just generally managing the day-to-day running of it.
When did you leave the Blackpool office?
I transferred to Polton Filed as a manager in 1981.
And how long did you stay there?
I'm not sure when I left there. I went to South Shore as a manager, but I really can't remember the dates after that. I was the manager at Polton, then I went to another branch office, but I really don't know when the dates were.
What was your next job after that?
After Polton, I went to South Shore, which is a bigger branch. And then from South Shore, I moved to Preston as the assistant manager because that was a much bigger office.
And then after Preston?
After Preston, I joined the retail line as a retail network manager.
When did you become a retail line manager?
Not sure, don't know the date.
Can you remember the decade?
Well, if that was, I think it was the 90s. I think. Yeah, it would have been late 90s.
Late 90s. And how long were you?
Yeah.
How long were you a retail line manager for?
From I think it was 1979 till I retired when I was 40 or 50. I was 50, I think.
So what's the date of your retirement?
Don't know, can't remember.
What was your job as a retail line manager? What did it involve?
It involved overseeing the running of 27 post offices. Originally it was 27, and then they did some sort of shuffling about where they took the smaller offices off, and I ended up with about 12, I think, of the larger offices.
And what does overseeing mean?
Well, not managing, because they all had their own. They were sub postmasters. So they ran their own office, but overseeing that everything was being done correctly, making sure they were adhering to all the standards that were laid down in the contracts, helping them if they'd got any trouble with anything, if they were having a bad balance in time or they were short of staff. Did I know anybody who could help them with the staffing issues?
Could we look, please, at poll 2011-8219?
Sorry, what am I looking at?
It's going to come up on the screen.
Oh,
And look at page 5, please.
page 5. Do I scroll it or will it just move? 3, 4, 5.
If you just wait a moment,
Oh, right, okay.
the right page will be displayed for you. And if we scroll down, please. Can you see this is a witness statement in your name?
Yes. Yeah.
This is one of the
Okay.
documents we provided you back in July to help you make a full and helpful witness statement. If we scroll up, please. And a little bit more, thank you. We can see it's dated the 16th of October 2003.
Yeah.
This is the first witness statement you provided in the post office's claim against Julie Wolstenholme of the Cleveleys Post Office, yes?
Yeah.
If we scroll down to paragraphs 1 and 2, there's an introduction there where you say then, that's October 2003,
Yeah.
you were employed by the post office as a retail line manager. You were previously called a retail network manager. There was
Yeah.
a title change, but not a job change.
Yeah.
And you've been employed since the post office since June 1980. Then if we go over the page, please. You told the court in this witness statement that your responsibilities include the monitoring of the overall performance of sub-postmasters against their contracts and business standards that are laid
Where am
down.
I looking at? Yeah, okay. Business standards laid down. Yeah, okay.
You told the court that you also monitor their yearly sales and financial performance together with gains and losses. And you say I'm responsible for a total of 112 post offices throughout the northwest area of England. Just breaking that down, what you told the court back in October 2003, is it right that your responsibilities as a retail line manager included the monitoring of the performance of sub-postmasters as against their contracts and business standards?
Yes. Yeah.
And you monitored their yearly sales and financial performance together with monitoring their gains and losses?
Yes.
And so is that a fair summary of your responsibilities as a retail line manager at this time?
Yeah. Yeah.
You told the court in this statement that you were responsible for 112 post offices.
They did change that at a later date. They
Who's
took the smaller, sorry,
who's the they in that sentence?
well, the senior management.
Okay.
They decided that the larger offices perhaps needed more attention, so the smaller offices were given to another retail line manager because they were smaller. They didn't need as many visits. They didn't need as much attention, and I think it was that the larger offices just needed a firmer hand than perhaps the smaller offices.
So the number after this time, after October 2003, came down from 112, is that right?
Yeah, most definitely. I don't want to swear to it, but I think my recollection was I had about 27. I've tried to work through them, but I really can't remember how many there were exactly.
You told us in your witness statement for these inquiry proceedings, and you've mentioned it this morning, that you were responsible for 27 post offices.
Oh, yeah, that's probably about right.
But when are you talking about then?
What am I talking about then?
I.e., what date?
I can't remember.
You see, in this witness statement here, Mrs. Cotton made much closer to the time in October 2003 and speaking about your time as a retail line manager managing the Cleveley's post office, you told the court that you were responsible for 112 post offices. Is that right?
It was at one time, but they changed it, and they just left us with the more senior ones had the bigger post offices.
I'm only interested in what happened in the period between 2000 and 2003. Does it follow that if we were looking at that period of time, i.e. before this witness statement was made, the accurate position was you were responsible for 112 post offices?
I really can't remember the dates. I really can't.
If you were responsible only for 27 post offices in October 2003, you presumably wouldn't have told the court that you were responsible for 112 of them, would you?
I really don't remember.
That's not a question about memory. That's asking if you made a sworn statement to the court which said I am responsible for 112 post offices in 2003, that's likely to be accurate.
And what date was that? What date
16th
was that?
of October 2003, as I told you and as we looked.
I'm sorry, I can't remember.
You think this might be inaccurate, what you told the court then?
We had that many. I remember when they divvied everything up, and there were retail line managers, and then there were I worked closely with another a young man, and he had the smaller offices. I had the larger offices. But as to the exact number, it's so long ago, I just can't remember.
I'll ask one last time. If you made a statement to the court swearing it to be true, in
I would have thought that was
hold
true
on,
at the time.
if you wouldn't mind, if you let me finish the question, and then I'll respect you by letting you give a full answer. If you made a witness statement to the court saying that you were responsible in October 2003 for 112 post offices, would that be likely to be accurate?
I can't remember.
So you may have written something down that was inaccurate to the court.
I would have believed it to be true when I wrote it.
Good. What was the nature, that can come down, thank you, of your dealings or interactions with the 112 odd post offices that you were responsible for?
I don't know what you mean. What was the dealings? It was just day to day.
Would you go into the post offices?
Yeah, yes.
It wasn't just phone contact.
No.
How frequently would you go into the post offices?
Depending on the size of the office, that it would depend on that, and it would depend on which area. I covered quite a few areas. I went as far as Southport, so I would go into Southport for a day, and or even a week, depending on how many there were, to try and get to see them all. You didn't really need, well, I didn't really need to get to see them all because I could speak to a lot of them on the telephone. They didn't really want you there if they were performing correctly. But it was my job to visit them all as and when I could. Some needed more visits than others.
Averaging things out, how regularly would you be in contact with each branch?
Some of them weekly, some of them monthly.
Thank you. As a retail line manager, to whom did you report?
Tony Biolki. He was my manager.
And where was he based?
He was based in Preston.
And did you have an office in Preston or a base in Preston, or did you work remotely?
We worked remotely.
Were you responsible for managing anyone other than the sub-postmasters?
No.
And so the manager part of your title, retail line manager, refers to the management of the 112 sub-postmasters?
They split it. There weren't 112 in the end because it was too many, and the smaller offices were given to another retail line manager.
I was working on the basis of the answer you gave earlier that this figure of 112 in your statement was likely to be correct. We're not interested in anything that happened, in fact, after the end of 2003, with you as a witness. So I'm not asking about how things developed.
I really don't remember. I mean, if I've put that in the statement, then I must have thought that at the time, but I don't remember having 112.
Can you recall being part of the team that recruited Mrs. Wolstenholme, Julie Wolstenholme, to the position of sub-postmaster at Cleveley's post office, and the transfer of the post office from her sick father to her?
The team? I don't know what you mean about the team.
Were you one of a number of other people that were involved in the process of transferring the branch from Mrs. Wolstenholme's father to her?
Yes, I was.
Can we look back at your civil statement, please? It will come up on the screen. There's no need to say anything until it does. Poll 0011 8219. Can we go to page 6, please? And can we I think that's page 7. Thank you. Can we look at paragraph 4, please? You told the court back in 2003, I first met the defendant, Julie Wolstenholme, through her father, Mr. Jackson, as Mr. Jackson was formerly the sub-postmaster at Cleveley's modified sub-post office. Mrs. Wolstenholme worked for her father for a period whilst he was the sub-postmaster at Cleveley's post office. Is all of that accurate?
Yes.
In paragraph 5, you told the court, in 1999, I became aware that Mr. Jackson was ill and had been trying to sell his post office. During my discussions with him regarding the possible sale, we discussed the possibility of a family transfer being made to Mrs. Wolstenholme. In or about September 1999, I met with Mrs. Wolstenholme, Mr. and Mrs. Jackson, and Mrs. Wolstenholme's former partner, Roger Harrison, at the flat above the post office premises, where we had a general chat about the possible family transfer of the post office to Mrs. Wolstenholme. Is that all accurate?
Yes.
In paragraph 6, if we scroll down, please. You say, after the meeting, you received a letter from Mr. Jackson dated the 21st of September 1999, and we've got that, resigning from the post office at Cleveley's modified sub-post office and requesting that the office be transferred to Mrs. Wolstenholme. A letter was sent to Mrs. Wolstenholme on the 12th of October 1999, enclosing an official application form for her to complete, and you produced those. And we've got those. In view of the fact that the transfer was a family transfer, I did not need to have sight of a business plan, nor was the formal interview, which was again due to the fact that it was a family transfer and also because Mrs. Wolstenholme had worked at the post office. And then you set out some other information that we needn't go into. Is all of that accurate that I've just read to you?
Yes.
Now, I think as part of this process, you completed an assessment for the post office of Mrs. Wolstenholme's suitability to be a sub-postmaster. Is that right?
Yes.
Can we look, please, within this same package of documents at page 39? Do you recognise the handwriting?
No.
Can we look, please, at page 43? Do you recognise the handwriting there?
Yes. Yeah.
Whose handwriting's that?
That's fine.
And then if we scroll down, please. And again.
Yeah.
And we see that you signed it. It's your actual signature is underneath those words, GRO. We're not displaying those so people know what your signature is. Saying that Mrs. Wolstenholme should be accepted as a sub-postmaster, and then you signed it at the bottom as well as the authoriser. Can you see that?
Yes.
Go back, please, to page 39. Can you see the answers to the questions there? Is that you writing those in?
Yes, I think it must have been.
And so the document's title is Report on Candidates for Sub-Postmastership.
Mm-hmm.
And does this document set out your assessment of the suitability of an applicant or a candidate for the position of sub-postmaster?
Yes, it was something we would do for a new candidate.
If we go to page 41, please. Let's look at page 40 so we can just see the kind of things are written out by you origins of plans to be a sub-postmaster? Why did the applicant first think of becoming a sub-postmaster? Whose idea was it? How well researched is it, etc.? And you wrote, the applicant currently works part-time in her father's office. His ill health is forcing retirement, etc. Yep, so that's the way it works. There's some pre-printed questions and then you write the text.
Yeah.
And on these pages, it's essentially an assessment of the candidate, here Mrs. Wolstenholme's plans and personal circumstances. Can we go to page 41, please? Question 4, consider the applicant's knowledge, experience and achievements, both inside and outside work, for a suitability for counter work. Clerical accounting, record-keeping aspects of the work give evidence. And you wrote, Julie's experience as a counter clerk and her substitution when her father is on leave is evidence that she has the skills needed for this work. And then on customer service, you said, again, Julie is used to dealing with customers and enjoys working at the counter. Yes?
Yeah.
And then over the page to page 42, please. And if we look at the bottom half of the page, please. Question 5C, is the candidate likely to be responsible in the job? Have you any reason to doubt the candidate's honesty? Look at previous jobs to see if responsibility was given or taken, give evidence. And you wrote, Julie shows a keen sense of responsibility. On my evidence of having seen her at work, and I have no reason to doubt her honesty. And it looks like you originally wrote, I have no doubt of her honesty, but changed that to I have no reason to doubt her honesty. Yes? And is that right? You had no reason to doubt Mrs. Wolstenholme's honesty?
That was correct at the time, yeah.
And no doubt that's a very important assessment when considering whether to recommend a candidate for appointment.
Yes.
And no doubt a very important consideration when deciding whether to take the candidate on.
It is, but it's very difficult if you haven't worked with them for very long. I mean, you know, at any time when you're interviewing a sub postmaster, you have to take a lot of you can't test their honesty in an interview. You can only go off. I mean, it's different in Julie's case because she'd been working with her parents.
And it was on the basis of that evidence that you had no reason to doubt her honesty, presumably.
Yes.
When a few months later you're deciding whether to suspend and then terminate Mrs. Wolstenholme, do you bring this information into account that you spoke to her honesty just a few months before?
Yes. I had to, as it was later, Julie was the sub postmistress and she worked very closely, which I wasn't aware of at the time, but I soon picked up on when I was going to the office. She worked very closely with her husband. And he was heavily involved in the day-to-day running of the office. And that was not taken into consideration because I wasn't aware that that was going to be the case when Julie was appointed.
And why are you telling us this?
Because I think it's relevant.
And why do you think it's relevant?
Because, I'd rather not say. I have no proof of what I want to say.
What do you want to say? Go on, tell us.
No, I would rather not.
Are you hinting that you think he was the dishonest one, not her?
I'd rather not say.
Was
I
that
have no proof at all of that. But he was heavily involved in the day-to-day running and the financial aspects of that office.
And did you have this suspicion without proof at the time?
Yeah, I still have no proof of it.
But did you have the suspicion without proof back in 2000
Yes.
when you terminated her contract?
I didn't terminate her contract on that. I terminated her on the balance of the evidence that I had.
Was that in your mind when you terminated?
No. It was on the evidence that the office wasn't being run properly, but I had no evidence of who was not running it.
Can we go to page 43, please? Your overall assessment, you said, I feel Julie will be successful in this venture. She's a good grounding, having worked in the office and also drawing on her father's experiences. She sees the need to move forward towards a better retail environment in the office. She's already considering streamlining the staff as she identified excessive hours being used. Long term, I feel she'll make a good office better. And then Julie is committed to becoming a sub-postmaster. She enjoys the work. She has the full support of all her family, which will help her through her difficult induction as a sub-postmaster. She's shown a great enthusiasm for Horizon and is keen to take the office forward and make a successful business for her and her family. And that was your overall assessment of Mrs. Julie Wolstenholme, yes?
Yes. Yeah.
And so you were positively and rather strongly recommended her for appointment, is that right?
I recommended her, yes.
We can see that an offer was made, if we go to page 44, to Mrs. Wolstenholme for the sub-postmastership of Cleveleys on the 9th of November 1999. Yes?
Yeah. I can't see that far down now. Oh, yeah, 9th of November.
First sentence, I'm delighted to inform
Yeah.
you your application
Yeah.
has been successful. And the date is in the top right, 9th of November 99.
Yeah.
And then within a couple of months after that, is it right that the Horizon system was installed into this branch?
I don't remember the date.
Can we look, please, at page 7 of this bundle? This is your statement to the civil court back in 2003.
I didn't know there was a civil court. The first I knew that there'd been a court case was when I got this bundle of documents.
You provided this witness statement to the civil court.
Oh, I don't remember doing that.
It's got your name and your signature on it.
It may have, but I don't remember doing it.
Let's see whether what you're recorded as having written is accurate. Paragraph 8, you deal with the report we've just looked at. I've actually looked at some of the things you said, whereas this statement doesn't include anything about your positive recommendation. But let's go to paragraph 9. Thank you. There's the letter that we've just looked at, the 9th of November. It says 2003 here. It's 1999, in fact. Letter. Yes?
Yeah.
And then paragraph 10, you said, in the early part of 2000, the post office installed the Horizon computer equipment at its post offices and sub-offices. The installation of Mrs. Wolstenholme's post office was completed on or about the 9th of February 2000. If you told the civil court that in this witness statement, is that likely to have been accurate?
It's likely to have been, yes.
And you continue, the original installation had been aborted on the day of installation due to problems with the ISDN line. And so was it right that there were problems with Horizon at Cleveland's from the very first day?
You can't say that. You can say there were problems with the ISDN line.
So
The
you,
installation of the line. I can't say there were problems with the Horizon from that day. It says there it was due to problems with the ISDN line.
let's scroll down then. Paragraph 11. You told the court that following the installation of Horizon, postmasters, sub-postmasters and their staff had two helplines which they could call in the event of any problems. One was the Horizon System Help Desk, which I'm going to call HSD, which dealt with technical problems encountered with, for example, the system crashing or in relation to the hardware or software. The other helpline was the Network Business Support Centre, which I'm going to call NBSC, which was run by the Post Office, which dealt with the general use and working of the system. Is that all accurate?
Yeah, two helplines. The staff had two helplines, Horizon Help Desks, and the other was the Network Business Support Centre. Yeah, yeah.
Okay, can we go over the page, please, to paragraph 12? You told the court Mrs. Wolstenholme persisted in telephoning the Horizon Help Desk in relation to any problems which she had with the system. And generally, these problems related to the use and general operation of the system and were not technical problems relating to the system. Copies of the call logs for the period 10th of January 2000 to 30th of November 2000, together with a brief analysis of the calls to the Horizon System Help Desk, which I prepared following Mrs. Wolstenholme's suspension, are at pages, and then you give some pages to an exhibit. Whilst there were some problems at other branches, they were not insurmountable, were often due to the system crashing or were general teething problems. So just dealing with problems at the Cleveland's post office with Horizon first, and then turning to the last sentence there, problems at other branches in a moment. You, in this statement, exhibited, attached to this witness statement, call logs from the Horizon Help Desk for a period of the 10th of January 2000 until November 2000, 30th of November 2000. Yes?
I don't remember getting these call logs. I think I've got them in the bundle now, but I don't remember asking for the call logs.
It seems that you had them by the time you made this witness statement in October 2003, because you attached them to your witness statement and said, they're my exhibit, EMT, the EMT1, M being your middle name, or the first letter of your middle name. Yes?
Yeah, I don't remember them. I've got them in the bundle now, but I don't know why I would need them really.
You mean you
Because
don't?
I wouldn't really understand them.
In any event,
there were technical issues. I mean, you know, due to the system crashing or general teething problems, but I couldn't do anything with that.
Mrs. Cottam, you're getting a bit of ahead of where we want to go. At the moment, I'm just asking a question that you appear, is this right, in a statement made to the court in October 2003 to have exhibited some Horizon Help Desk call logs as your exhibit, EMT1. And
Which court was this? I haven't been to court.
no, it never reached court.
Oh.
Post Office settled.
Oh, right. Well, I didn't even know there'd been any sort of court case until I got this bundle of documents.
We've got a witness statement from you signed with a statement of truth which says, I attached to this witness statement 84 pages of call logs and my analysis of them. Okay, let's start on the basis that that is what this document shows. So these 84 pages of help desk records and your analysis of them, I just want...
I do not remember that at all.
Well, maybe I wouldn't blame you because it's 20 years ago.
Yeah, well, I don't
almost to the day.
remember. I don't remember that at all. I mean, I'm sure 28 pages.
No, it's
I just-
84 pages
Now,
between pages 28 and 112. And I'm going to look at them if we may. So if we turn to page 48 in this bundle. This is the first page of that exhibit, EMT1. Okay?
the first I've seen of these is when I got this bundle of papers. These I hadn't seen these before.
You didn't see them back in 2003 when you were making this witness statement to the court.
Not that I remember.
In any event, they're attached to your witness statement made to the court,
Right.
and the first of them is dated the 9th of February 2000. Can you see that?
Yes, I can see that.
And basically, over the next 84 pages, there are further call logs and then an analysis of them that you prepared according to your witness statement at the time.
I don't remember making any analysis of this at all. I just don't remember having to analyse these at all. I don't think I would really understand it.
Well, that's one of the things I'm going to be asking you about in probably in about half an hour's time. Why were you telling the court what the help desk's record showed when you made
Because
the
that's what the help desk would have shown me.
Let's just,
I don't understand these. I don't understand them. I don't know what it's saying. Gateway is now stuck at 3%. That means nothing to me.
no, and as I said, in about half an hour or so, I'm going to be asking you some questions about that.
Right.
Let's just look at what the documents are to start with, if we can, Mrs. Cottam. You see the first one on this page, 9th of February. Over the page, please. Another call on the 9th of February. Over to the next page, please. Another call on the 9th of February. Page 161. Sorry, page 51. Another call on the 9th of February. Yeah, the date of installation. Over the
What
page.
am I looking at? What am I supposed to be looking at these?
All I'm doing at the moment is reminding you of the number and nature of the Horizon Help Desk call logs that you exhibited to your witness statement on the 16th of October 2003.
But I would have requested these. I wouldn't have seen them. I don't remember these at all.
Let's carry on. 10th of February. So we've got a handful on the day of installation, the 9th, and then more on the 10th of February, and then over the page. Another call on the 10th of February, over the page. Another call on the 10th of February, over the page. Another call on the 10th of February, over the page. Another call on the 10th of February, over the page. Another call on the 10th of February, over the page. Another call on the 10th of February. And so it goes on. Do you see?
Yeah.
And then if we go forwards to the
So who's
last...
the caller? Who's the caller on this? Mr. Harrison. But he's not the postmaster, is he?
And what's your point?
Well, he doesn't feature very heavily anywhere, does he? And yet his name's on all these now.
And what's your point?
Well, it says titled postmaster, and he wasn't, was he?
And what's your point?
Well, he's not the postmaster. So is that correct?
What do you mean, is it correct?
Well, well, nothing. It doesn't matter.
Is this the suspicion without proof issue raising its head again?
I'm not going down that line at all.
I thought you just did.
Well, I'm just saying here it says that the caller was Mr. Harrison and he's the postmaster, and he wasn't.
If we go to the last of the documents in your exhibit, if we look at page 115, please. You'll see this is dated the 21st of June 2000. And the caller is Julie, the postmaster, yeah?
Yeah.
In your witness statement, you said that you were exhibiting the calls, if you remember.
No, I don't remember.
All right, well, I'll read it out to you.
Okay.
Between the period 10th of January 2000 until the 30th of November 2000. In fact, the calls that are exhibited are between the 9th of February 2000, the day of installation, and the last one is on the 21st of June 2000. Do you understand the point I'm making at the moment? Your witness statement said calls are between 10th of January to the 30th of November, and the calls that you've in fact exhibited are between the 9th of February and the 21st of June. Where would you have got these documents from?
I don't know. I don't know. I don't remember this at all.
If you were approached in 2003 to make a witness statement, and we know that you did, and one of the things that you did was attach to your witness statement a series of calls and call logs, how would you have got those?
I don't know.
Can you try and help us as to...
I will try and help, but I don't. I just don't know. What is that? Is this? Are these things in this bundle that I was sent?
Yes. Both the witness statement I'm quoting from and your exhibit to it.
What page is that, please?
It's in tab D7. The bit of your witness statement I'm reading from is at page 8 of tab D7, and the call logs that you exhibited to your witness statement start
I'm
at page
sorry, I'm what?
48. Well, that's why I haven't asked you to look at any documents in a pack in front of you, because people tend to get lost, and instead I've displayed them on the screen.
Page 48 of what am I looking at? Because my page 48 is just about general sub-postmasters. It's not. I don't know what I'm looking at.
Shall we just stick to the documents I'm displaying on the screen then?
Yeah, but yeah.
Good. Where might you have gone in October 2003?
Oh.
I'm sorry if you find this uncomfortable.
I'm sorry. Can you just have a break at the moment here, because I'm not remembering any of this. Can you just give me 5 minutes, please?
Yes, of
Yes,
course. Yes.
Oh, go on. So you're back. I wonder whether we might take a 15-minute break now.
Yeah, by all means, yeah.
Thank you, sir.
It's not normally something that I'd say openly at this stage, but this is a very unusual situation. It's certainly in my mind that the most likely explanation for this witness statement is that the documents that you've just been looking at were obtained for the lady, and it may perhaps be fruitful, I'm only making a suggestion, to take her directly to her analysis to see if in fact at some stage she did analyse the documents.
Yes, that was the next series of questions to
Well,
look at.
I'm sure they were, but she's becoming so confused about things, I think, Mr. Beer, that your methodical approach may be more easily achieved by just asking her directly about the analysis, because if she acknowledges that she did make an analysis, at least we've got that. If she doesn't even acknowledge that, I don't know where we go from there.
So just so you know where this is going, we're in possession of some significant call logs that weren't exhibited, that involve Mrs. Tagg, as she then was, Mrs. Cottam now, in liaison with the help desks, complaining over problems with Horizon. And the the issue to be explored is why wasn't that revealed to the civil court?
Yeah. All right. Well, then I'll, as they say, butt out. Mrs. Cottam, we've decided we're going to have a 15-minute break now.
I think she's gone. I think she's gone already, sir.
No, she's back on my screen. Yeah. So we normally have a break at about now. So we're going to have a 15-minute break now, and you compose yourself, all right? I know this is difficult for you, but we'll come back again in 15 minutes, and Mr. Beer will ask you some more questions then, all right?
Great. Thank you.
So good morning. Can you continue to see and hear me?
Yes, I can, thank you.
And Mrs. Cottam, can you see and hear me?
Yes, I can.
Thank you. Can we have on the screen, please, poll 0018-8219? And look at page 8, please. And highlight paragraph 12, please. This was the paragraph that we looked at earlier of your civil statement to the court. And in the fourth line, you said copies of the call logs for those dates, together with a brief analysis of the calls, which I prepared, are at, and then you give some page numbers. Do you see that?
I do, but I didn't write all this.
Who wrote it?
I think, I know I was heavily involved with the contracts manager. He was called Paul, but I didn't write all this.
You said that you were heavily involved with the contracts manager, Paul. What was Paul's surname?
I think it was Paul Williams.
And
But
was
there
he?
was also somebody called Rebecca Robinson. She was involved in. If I had to write to any post office, because I wasn't like, I didn't have any in-depth knowledge of the contract between sub postmasters and the post office, you know, the contractual legally binding stuff. I always got them to draft the letter for me. So I may well have signed it, but the content would have been through the contracts manager.
Okay, this isn't a letter written by you. This is a witness statement made by you to the court.
Yeah, I don't remember this at all. I don't remember it.
Do you remember seeing a solicitor?
No, I went to, the only time I've been to see a solicitor was about a couple of months ago. And that was only on, I don't remember seeing a solicitor at all.
So you think somebody else may have written this statement and you signed it?
If it's about contracts and things like that, they would have drafted it for me, definitely.
And the they is Paul or Rebecca, is that right?
Yeah, well, it may have been, but it would have been through the area office, the district office, because any letter that was like that, I would have always put through them first, because they would know the technicalities of it. Oh, you can't say that, or you've got to quote this, or you've got to quote the other. So I may well have signed lots of letters.
Again, just to be clear, this isn't a letter, this is a witness statement to the civil court with your name on it, and you...
The civil court?
Yes, to Blackpool County Court.
I don't remember that. I don't remember that at all. The first I knew that there'd been any sort of court case was when I got this bundle of documents.
Well, in this document, which has got your name at the beginning of it, your name at the end of it, and your signature on it,
Yeah.
it says, I prepared an analysis of the call logs. Can you see that? It's the bit
Yeah.
that's highlighted.
But I would not have prepared. I may well have signed it and not really understood what I was signing it, but I wouldn't understand the analysis of the call logs.
Let's just look at the analysis of the call logs. They start at page 118. It's going to come up on the screen for you.
Yeah, I've got them all here.
Can you see a reference number is given in the first column?
Right.
The status of the call, whether it's closed or open, is given.
Yeah. Yeah.
Priority and severity is rated. When the call was open and closed is given.
Yeah.
Which FAD, which branch or site,
Yeah.
etc. And then on the right-hand side, two columns in, is the problem text and then the closure text. Can you see that?
Yeah. Yeah.
Did you prepare this?
No, I would never see these. No. Never seen them until I got this bundle.
Can you help us as to how it came about that there's a witness statement to the Blackpool County Court in your name and signed by you as true, which says, I prepared this analysis?
No. No, I can't, because I don't ever remember seeing it. I mean, it was a long time ago. I may well have done it, but I really don't. I just wouldn't understand it.
Okay, I'll take those down then, please. Can we go back to the statement that you provided to this inquiry, WITN, it'll come up on the screen for you, WITN 0953 0100. And it's the second paragraph from the bottom. Against para 4, that's paragraph 4 of our questions to you, where we'd ask you whether you had any direct involvement with the help desk. You said, I don't remember having any direct involvement with the help desk.
No.
And by that, did you mean that you may have had involvement with the help desk, but just because of the passage of time, you may not now remember, or...
Yeah, I don't remember.
Or you don't think it's the kind of thing that you would have got involved in?
I don't think it was the kind of thing I would have got involved in, because I'd never used Horizon. So I didn't know how to use it. So if they were asking questions about it, I wouldn't have been able to answer.
Okay, can we just look at some documents then, some underlying material, to see what the position was back in 2000? And the purpose of me asking you these questions, just so that you know in advance, is when we come to the suspension and termination decisions, I want to ask you some questions about your own personal knowledge of problems with Horizon and the extent to which that was brought into account in decision making. Okay? That's why I'm asking you about these issues. Can we start, please, with FUJ 0012 1216? FUJ 0012 1246. I'm sorry, Mrs. Cottam, there's just a delay at this end in displaying a document.
Okay. Thank you. And can we expand the top part? Can you see this is a record of a call? It's to the Horizon Help Desk. Opened on the 24th of February 2000 and closed on the 1st of March 2000. Can you see that at the top there? Yeah,
And can you see the caller is shown as Mrs. Tagg?
it is, yeah.
And that's you and your maiden name, is that right?
It is, yeah. I don't remember making that call, obviously. It's so long ago.
And the problem text that's recorded is couldn't print due to a session being suspended last night, has rolled stock unit and the office into the next week, rebooted to clear the problem.
Yeah.
And then,
I wouldn't have done that, though. Because I wouldn't have known how to reboot or roll or... Well, that's would have probably what happened, but I personally would not have done that.
and so why would you be calling in the help desk?
Why would I be calling them? To ask them how to do whatever it was they were doing. But I would get the postmasters to do it.
But this is you calling in. Why would you be
Yeah.
calling the help desk?
Because I would have been at the office trying to help them sort out whatever it was.
Why wouldn't the sub-postmaster call in?
Well, she probably did.
No, she didn't, you
He
did.
did. We were looking for some advice from somebody.
So did you just say, or he did?
I don't know, I can't remember.
Was that
I
slipping
can't.
into the suspicion without proof thing again?
Well, I wouldn't like to say.
No, but you just did.
Well, I'm sorry, I did.
Anyway, this is a record of a call made at 8:05 in the morning by you. And I'm asking, why would you be calling in?
Because they probably would have rung me and said that we've not been able to roll over and what can we do? So I only lived locally, so I went. I must have gone.
Okay. If we look at under all of that black and grey text into the call activity log, I wonder if it can be highlighted. First line, new call taken by Andrew Abernethy. Couldn't print due to a session being suspended last night. Has rolled the stock unit and the office into the next week. Rebooted to clear the problem. And then 3 lines on, 4 lines on, she would like this investigated as the gateway needs rebooting about 3 or 4 times a week as it keeps freezing, can't touch anything on the screen, no hourglass spinning.
Are they saying I said that? Because I don't remember saying that.
I wouldn't expect you to remember 23 years on.
But
You
I
having-
don't think
you-
I would do that. I don't think I knew how to reboot or... But if that's what they say, that's what they say. I can't...
If we look, so this is the first record that I can see of you being recorded as calling in and raising an issue or complaining about a Horizon system fault or problem. Your present recollection is that you don't remember ever doing that, is that right?
If I don't remember it, but it's likely that I would have gone and tried to sort something out for them. But I can't say I remember that on the 24th of February, year 2000. No, I can't.
Okay, let's go to FUJ 0012 1296. Again, there's a problem displaying the document, so we may have to wait a little bit. Again, if we can expand that a little bit, please. Can you see this is a record of a call made on Friday the 31st of March 2000 at 5:35 in the evening. And the caller is Elaine Tagg, the RNM, the Retail Network Manager. Can you see that?
Yeah, I can.
And the problem is recorded as the system keeps crashing and is doing 3 or 4 times a day and is getting worse. They've had several base units installed, but the problem persists. Yes?
Yeah, I don't remember making this call. I don't remember making this call. I might well have done, and if that's what they said and my name's on it, fine. But I don't remember it.
That can come down, thank you. The first call record we looked at was very shortly after the system was installed, a fortnight or so. And then this one was a month later with, on both occasions, you being recorded as system crashing 3 or 4 times a week, gateway needing rebooted.
I don't remember that. I wouldn't know what gateway rebooting meant.
When you came to make decisions about suspension of Mrs. Wolstenholme in November, would you have taken into account your knowledge of problems with the system that you yourself had reported?
We would have taken into account that the system, you know, they were saying the system wasn't right and this wasn't working, but that was not the basis. The basis, if I recall correctly, the basis of why the contract was terminated is that they refused to use the Horizon system and they refused to repay the losses.
and they refused to use the Horizon system because it kept crashing and needed rebooting, and it was giving them problems with balancing and shortfalls, correct?
I don't know if that's correct or not. That's what they said, but I don't know that what they said was correct.
If we just go back to your civil statement, poll 0011 8219. At page 8. In paragraph 12, you said Mrs. Wolstenholme persisted in telephoning the HSD, yes?
Yeah,
You don't refer in this statement to any of the calls that you made to the Horizon Help Desk, and instead seem to give the impression that this is Mrs. Wolstenholme persisting, i.e. perhaps unnecessarily bothering the Horizon Help Desk. Is that correct? That was the impression you were trying to convey?
I wasn't trying to convey any. That's what she did.
You only speak in this statement about Mrs. Wolstenholme phoning in, and you use the word persisting, or she persisted. You don't refer to you calling in, identifying problems.
Well, I wouldn't have been there every time the problems occurred.
Would there be any reason why you didn't refer in this witness statement to you reporting problems about Horizon to the help desk?
No?
Can we look, please, at FUJ 005 5145? Display problem again. We'll be back with you shortly. This is a pinnacle, as it's called, opened on the 2nd of November 2000 and closed on the 7th of November 2000. Do you know what a pinnacle is? Do you recall what a pinnacle is?
No?
Had you ever heard the phrase before?
No?
You'll see it's dated the 2nd to the 7th of November 2000. So 2 or 3 weeks before Mrs. Wolstenholme was suspended on the 30th of November 2000. You understand?
Yeah?
Let's look at what it records by looking at activities. In the third line, PM has noticed that the adjust stock figures from shared stock unit AA are showing in shared stock unit RJ and vice versa. Postmaster viewed the adjust stock figures in stock unit RJ, and it showed 20 times £20 smart creds that were REM'd into stock unit AA on a time and date with a session ID. These have not been transferred across to stock unit RJ, but are showing on the adjust stock screen. Balance snapshot, correct. And then a couple of lines on advice. Postmaster advise that this is an intermittent problem occurring since the counters were upgraded on the 23rd of October. And then over the page, please. Third line, repeat call. Postmaster phoned back and still has not heard from anyone. Voiced Phil at SMC. Do you remember what the SMC was?
No.
The second line of support. As soon as he can, advised postmaster of this. And then 2 lines on, repeat call, still awaiting a reply, getting very upset, waiting to balance and get to family, etc. 2 lines on. Information, HSH contacted SMC for an update, advised call him with SSC. Do you remember what the SSC was?
No.
We know it as the third line of support. Will be dealt with as soon as possible. And then 3 lines on, follow up. RNM, Elaine Tagg, that's you, called re the call. She is on her way to the office and wants updating on the situation. Spoke to reference Kath on the 3rd line, I think that's the 3rd line of support, who advised she will check who is working on the call and get them to ring the office as soon as possible. Message relayed back to the retail network manager. Retail network manager not very happy with the response. Do you recall this kind of event where there would be a problem at the Cleveleys branch? You would go round to the branch, recorded here, you're on your way to the office, and you would be calling in complaining about the response of the help desks.
No.
Would you accept that?
I wouldn't really have known unless they told me when I got there. If the helpline hadn't called me, which I don't think they would have done, I wouldn't have known until I got to the office. They would have had to tell me they'd been onto the call line, the helpline.
Okay, this has got you calling in to the 3rd line of support.
Yeah, so I must have called them because, they must have asked me to go to the office, wanted an update.
Anyway, you're recorded as not being very happy with the response of the help desk. Do you see that?
Yeah, well, I can't remember why now, that's that long ago.
No. Then if we go over the page, please. At the top of the page, first line, halfway through, advised postmaster needs to contact the MBSC and let them know of the situation, as they will probably not be able to do a cash account.
I don't know what that means.
Can you recall what the MBSC was?
No.
Can you recall what doing a cash account was?
Yeah.
What was doing a cash account?
It was doing the weekly balance.
Reading on, repeat call, RNM calling. They've called a few times now.
Hang on, I can't find that. Where's that?
So it's just after the passage that's highlighted. The next line, that's it.
Yeah.
RNM calling, that's you. They have called a few times now, expecting a call back with info, and no one has called them. The office is closed, but they're waiting for a call. Reading on. Repeat call, voiced EDSC while speaking to them, PM terminated call. Call summary has changed. Postmaster has noticed that the adjust stock figure from has been changed to adjust stock figures from shared. And then reading on, so 5 lines on, contacted the RNM, that's you, for this office, as she's now made a complaint regarding this issue. Elaine, retail network manager, advised that all stock units have now been rolled over and they're now checking them to see if the final balance is showing to be correct. One of the stock units had something added to it whilst rolling over. Can you remember what rolling over was?
Yeah.
What was rolling over?
You would balance on the Wednesday night, and then you rolled it over to the Thursday to start afresh.
And
So
this-
that was like, say that was week 1. Week 1 would be ended. You'd roll it over into week 2.
And this is a Thursday morning. Take it from me that the 2nd of November 2000 was a Thursday.
Yeah, sometimes they did it on a Wednesday night.
And if, when rolling over, the system added something to a stock unit whilst rolling over, that would be a problem, wouldn't it?
Well, I'd never come across that.
Do you accept that? This is
The-
recording.
The system couldn't add something to it.
It just couldn't.
Someone or something must have added something to it. You're just rolling it over. You're rolling £100 over. It should show £100 in the next week that you're starting with. This
is recording you lodging a complaint at a failure of the help desk to deal with the issue. And you telling the help desk that one of the stock units had something added to it whilst rolling over. That's not Mrs. Wolstenholme or Mr. Harrison adding something to the stock unit, somebody adding something. You're telling the help desk here that there's a problem with the system, aren't you? A stock unit has had something added to it.
Well, yeah. How it was added to it is another matter.
No, and that's what you're, if we continue, Elaine, that's you, was very annoyed that no one from third line had called her back. She has been promised a number of callbacks. And then over the page, please. Apologised for her not receiving any callbacks and advised I would escalate the fact that the agent she has spoken to have promised callbacks within the hour, as they should not be making promises like these. Advised her that third line are very busy with their investigations and sometimes do not have time to call back. They may call back sometimes if they require additional information or actions. Advised I would monitor the call. If any updates occurred, I would notify them. And then there's some information about assigning it to a team member. And then if we read on a little bit, 4 lines under response. Can you see that?
Yeah.
It says there is a KEL for this problem. Did you know what KELs were?
No.
Had you ever heard of anything called a known error log?
No.
Anyway, it says there is a KEL for this problem, and the reference is given, LKINANG 351M. The KEL explains that it's currently being investigated by development. I've not spoken to the customer. Had you been told that there was a system maintained by Fujitsu, who operated Horizon, that recorded known errors, known problems with the Horizon system?
Had I been told?
Yeah.
No. No.
There's a record here that one of those known problems, known errors, is seemingly afflicting the Cleveleys branch, i.e. there is a KEL for this problem?
No, I didn't know that.
And then there's nothing relevant on the remainder of that page. Go over the page. Contacted PM, this is 3 lines in, on the 6th of November. Further information requested on the known error log. Adjusted. Everything was okay. All stock showed correct value. Reading on, showed all AA figures, stock units. So Postmaster had adjusted back to RJ value. Then RJ, it showed all negative figures, but the negative value reflects as a stock value, but in negative format. And then an example is given. And then at the foot of the page, 4 lines up, more information has been received with regard to this problem. Is the KEL available, as I'm unable to locate it? Please, can this be investigated further? Then over the page. Five lines in, see KEL, and then that number is given, already specified. Postmaster has not been contacted, closing as published known error. And then the call is closed. So you didn't know about the known error log?
No, never heard of it.
There's no record on here, or indeed elsewhere, of you or the sub-postmaster being told that a known error in the system occurred, which was affecting the balancing process. You see, there's no record on this Pinnacle.
No, well, no, I didn't know about it.
Instead, the service desk closed the call, don't contact the sub-postmaster, and they close it because it's a known error with Horizon. Can you see that?
No, yeah, I can. Didn't even know there was such a thing.
Would this be important information that you would want to take into account or ensure that decision makers took into account when coming to decide 3 weeks later to suspend Mrs. Wolstenholme and then terminate her contract?
If there were known errors, and this was the first time I'd heard about it, you'd have to take that into account. I'd never. This is the very first time I've heard about a known error. So, you know, you don't know how many times it would have been. You couldn't just say on that one statement that it would have altered any decision. But certainly, if it'd been an ongoing thing, and there was a lot of published known errors, and you would have known about it, you would have had to take that into account.
That can come down from the screen, thank you. Do you remember in your civil statement, you said, I'm giving the court the call records between January and November 2000?
No, I don't remember that.
Well, let me just outline where I'm going. In your statement, you said, I'm giving you the call records between January and November 2000, exhibited
I'm
to
giving
my...
you the copy.
Yeah, in annex to my witness statement. And then we looked and we saw that they were in fact only between February and June 2000. And therefore they didn't...
I gave them. When did I give them the... Why would I have the...
Let's go back to your witness statement, poll 00118219. It's going to come up on the screen. And look at page 8. And paragraph 12. In the fourth line, you say copies of the call logs for the period between 10th of January 2000 and 30th of November 2000 are essentially exhibited by you, yeah? Are at page 28 to 112 of your exhibit. Can you see that? It's on the screen, Mrs. Cotton.
Yeah, yeah.
So you're telling the court there, I am exhibiting call logs between the 10th of January and the 30th of November. We've seen that the call logs that you in fact exhibited are between February and June. They therefore didn't include this November one.
I don't know where I would. I don't understand this because I wouldn't have been able. I didn't have any call logs.
I'll ask the question very generally. Why is it that your statement says you're exhibiting call logs between the 10th of January 2000 to the 30th of November 2000? And in fact, the call logs that are exhibited are between February and June 2000.
I don't know. I don't remember this document at all. I just don't remember this at all.
Can you help us how it is that
I can't. I will help you as much as I can, but really, I don't understand where all this is coming from. Am I supposed to have written all this? I might well have signed it, but I don't remember all this.
generally when you write something to a court and say, I believe the contents of this statement are true, and sign it with a pen underneath it, that indicates that you've written it.
What?
No?
When am I supposed to have signed this?
October the 16th, 2003.
I don't remember it. I don't remember it. And the very first time I knew there'd been a court case about this was when this has just been raised again, when they sent me this bundle of papers. I didn't even know there'd been a court case before that.
So you can't help us why the call log recording you on 2 occasions assisting Mrs. Wolstenholme, complaining about the service offered by the Horizon Help Desk, about a balancing issue and the system adding sums on rollover, was not included in the documents exhibited to you, to your witness statement. You can't help us there.
No.
3 weeks
can't
before she
see
was
it.
suspended.
Am I supposed to be looking at this now? Is it on here?
I simply don't understand what you're asking now.
Well, I don't understand what you're asking me. What?
I'm asking.
Are you saying that I got copies of calls logs and that's what I based the suspension on?
No, I've not asked that question so far. I'm asking you whether you can explain why the call log that we just looked at, which records you joining in Mrs. Wolstenholme complaining about Horizon, and on that occasion, the 2nd of November, complaining about Horizon adding sums on rollover to a balance, was not included in the information that you gave to the court.
I didn't give any information to the court. I wasn't called at the court case.
Do you think somebody has fabricated your signature on this witness statement?
Well, I don't know if that's the case or not, but I didn't know anything about the court case and I wasn't called to the court case.
Now, as I said, it didn't reach court because the post office settled.
No. But I didn't know anything about it. You would have thought that they would have at least approached me about it. They must have wanted some input from me at that stage.
Yes, this is a 15-page witness statement signed by you.
No, this statement of truth, yeah?
Yeah.
August 2004. I don't really understand what it is I'm supposed to be doing here, really. What I haven't got copies of the call log, so other than in this bundle, I don't understand.
If you had called in about a problem with the Horizon system, that can come down, thank you. If you had called in about a problem with Horizon, about it adding sums on rollover on the 2nd of November 2000, you would want to take that into account, wouldn't you, when deciding whether to suspend Mrs. Wolstenholme 3 or so weeks later?
Well, she was only suspended. It was perhaps, it might have been that we suspended her while we looked at the whole thing. I really can't remember.
Well, that was my next question.
I would have taken advice before suspending her. I wouldn't have done that off my own back. I would have gone to talked it through with the contracts manager.
When you said she was only suspended, what did you mean by that?
Well, suspended while we investigated.
And when you investigated, and she was saying, I've not taken money, I've not mismanaged money, I've been complaining for the past 9 months regularly to the Horizon Help Desk about this system, would you have got the call logs then to see whether what she was saying was true?
I don't know.
Would you think that's a sensible thing to have done?
It might have been. It depends what other information I'd got at the time.
Can we look, please, at poll 00118219? At page 179, please. If you just go back a page. That's the signature part. This is your letter to Mrs. Wolstenholme of the 5th of December 2000. And you told her that you wrote on the 30th of November confirming her suspension. And that was your decision to suspend, wasn't it?
Not only mine. And I wouldn't have drafted this letter. I would have gone to the contracts manager about this letter.
It was your decision to suspend her, wasn't it?
Yes, but I wanted to make sure that it was contractually correct.
And
So I signed the letter, and that was the case with most of these letters.
I think we've agreed that it was you that suspended her, yes?
Oh, well, yeah, it would have had to be me.
What investigations did you carry out before suspending her?
Well, it was an ongoing investigation, really. It was to do with, I'd been in the office quite a lot. We were looking at all the different things that were happening, and there was lots of cash losses and gains. The Bureau of Discharge was overstated or understated. Lots of things were taken into account.
And she was saying, in broad terms, it's the Horizon system that's the problem with this.
Yeah, she was.
And she was saying, and I have raised these issues with the help desk persistently over the last 9 months, wasn't she?
Yes.
And so did you check the call logs to see whether what she was saying was true and what had been done about her complaints?
No, I didn't really even know about call logs existed at that time.
But 3 or 4 weeks before you suspended her on the 30th of November, you yourself have been complaining to the help desk about Horizon adding a sum on rolling over. So you knew what she was saying was true, didn't you?
Well, I didn't know it's true. How would I have known it was true? I just said that that's what had happened. I didn't see it happen.
So what investigation did you carry out to see whether it was true?
I couldn't have investigated that. That was like a technical issue.
In any event, as we can see here, you say you wrote on the 30th of November confirming suspension. I've now reviewed papers. You're reviewing them. I'm considering termination of your contract.
Yeah.
And in the fourth line of the next paragraph, you say the excessive number of error notices is unacceptable.
Yeah.
During final audit, there were 4 error notices.
Yeah.
And next paragraph, your failure to account for official cash and stock properly, i.e. your refusal to operate the Horizon system, is a clear breach of your contract.
Yeah. And that letter was drafted for me. Well, the basis of it was drafted for me by the contracts manager. Because I wouldn't have known what to say, the section, parrot, this, and the other.
And so when Mrs. Wolstenholme was saying, the reason why I am now refusing to use the Horizon system is because it is riddled with faults, which are causing the very problems that you are accusing me of, what did you do to investigate at this stage, post-suspension?
Well, we were backwards and forwards to the helpline with it, but we didn't then. And that was not the only reason she was suspended.
I'm talking about post-suspension now. I'm talking about termination now.
Yeah.
What investigation did you carry out to judge the accuracy or reliability of the things that Mrs. Wolstenholme was saying in her defence?
Well, it was a Horizon system. That wasn't the only reason that she was suspended. That it was about the error notices that weren't being brought to account. There was a lot of that, despite letters. And I remember hand delivering these letters saying you need to bring these to account, and that was not done.
Would the calls made by a sub-postmaster to the MBSE, the 2 forms of help desk, be taken into account in making a decision on termination?
Yes, they would. But it wasn't all down to the Horizon system.
What do you mean?
It was all blamed on the Horizon system. But the error notices that were coming back were error notices where pension dockets were overstated. The foreign exchange wasn't done correctly. That was nothing to do with Horizon. That was false accounting.
She was false accounting, was she?
Well, I don't know who was false accounting, but it's what it was.
And so her raising the Horizon system in her defence was an irrelevant consideration to you?
No, it wasn't irrelevant, but it was not the only thing.
What was the reason for the termination of her contract?
I can't remember. Failure to account for official cash and stock properly, and the refusal to operate the Horizon system. And it was a clear breach of Section 12, Para 4 of the contract.
That relies on what Horizon was telling you, doesn't it?
Not the failure to account for official cash and stock.
How was the official cash and stock position recorded?
The auditors would have gone in and done that, the final audit. And they said on here.
Did auditors go in?
Yeah, of course they did. Final audit. I didn't do the audits. The auditors went in.
And do the auditors rely on what the cash and stock position is shown by Horizon in order to reach their conclusions?
I can't say what the auditors did. They would have looked at everything. They did a final audit, and they would go back and see about error notice that were issued and making sure pensions were brought to account correctly and not overstated, all that. But that was to do with the auditors.
Can we move forwards, please, and look at poll 2011 8242. And look at the second page, please. And scroll down, please. You're not included on this email chain. It's from Jim Cruz, a post office lawyer, to Mandy Talbot, another post office lawyer. And it's about the Cleveleys post office and Mrs. Wolstenholme. To give you some context, Mr. Cruz's email says, this case started back on the 17th of January 2001 with an email query from the then personnel department about the above office when the sub-postmaster's contract was suspended on the 30th of November 2000, as there were a large number of error notices on losses and gains. At that time, the losses were £14,000 and the sub-postmaster was refusing to make them good, blaming the losses on the Horizon system, which had been introduced in February 2000 at her office. That all seems accurate so far. She was given 3 months' notice and her remuneration for the 3 months due came to about £19,300, which was set against the losses. An attempt was made to install a temporary sub-postmaster at the premises, but negotiations eventually broke down. But Mrs. Wolstenholme had by then made a claim for rent for post office equipment remaining at the premises after the 30th of November. Claim was not accepted, and as it was felt to be in both sides' interest for the equipment to stay whilst there was a chance of a temporary SPM being installed. On the 7th of February 2001, the sub-postmaster's partner, Mr. Harrison, asked if ICL, that's Fujitsu, could look at the computer system as he believed there were problems with it. On the 23rd of February 2001, RH, I think that's Roger Harrison, refused to allow the safes and the Horizon equipment to be removed from the post office, which Post Office Limited wished to do as the claim for rent had been made. The refusal was because of the dispute with Post Office. Mrs. Wolstenholme asked for proof that the losses were her fault and caused, I think that should be, and not caused by computer failure. She also asked for copies of all error notices, but Chesterfield said these weren't available. And then this. On the 27th of February 2001, I advised Elaine Tagg that because of the allegation of computer failure, the printout should be obtained from the National Audit Team, showing a full audit trail at this post office. On the 28th of February 2001, Elaine Tagg told me that she had the call logs for the office. Is that correct, that you were tasked by this post office lawyer to obtain a full audit trail for this post office, and you replied that you had got the call logs for the office?
That letter, I wouldn't have written that letter. It was, if it's gone from Jim Cruz to Mandy Taylor, that would have been drafted for me. Now, I wouldn't have had...
Just to be clear, sorry to speak over
have...
you. This isn't a letter written by you or suggested to be a letter written by you. This is an email between two people referring to something that one of them says he did with you, namely asking you to get a full audit trail and you replying saying you had got the call logs for the office. Yeah?
and he said that, did he?
Yes, you can see it on the screen.
Who said I had them? Roger Harrison said I had the call logs, did he?
No. Mr. Cruz said to Miss Talbot that you had got the call logs.
Well, I don't remember that. If I had the call logs, they would have been in the Cleveleys file that was delivered to Leeds area office by myself, because everything that I had following this case, I personally took to Leeds in the file.
Would the audit trail or the call logs for this branch only have been obtained after suspension and after termination?
I don't know. I can't remember that.
In the absence of audit data or call logs, what was the evidential basis for the suspension and then termination of Mrs. Wolstenholme's contract?
I'm looking for the official wording for this because I don't want to get this wrong. I think it was, I don't know where it is, but somewhere it was about refusal. Within it was about refusal to bring, and I can't quote this and say absolutely, but it was refusal to bring error notices to account, fault accounting, and what's the other thing? Refusal to use the Horizon system. Did I say that? There were several things.
And I'm essentially asking is, by the time that those several things were decided upon, had you obtained a full audit trail for the post office concerned?
I wouldn't have done that. The audit team would have gone in and they would have done all that, the full audit trail.
And what did auditors do? Did they just check stock and balance on the day that they went in?
They did everything. They checked everything.
What does everything mean?
Well, everything that they would need to do. I don't know what an audit team did when it went in. I know it checked cash and stock. It used to go back through to, in some cases, they would recall pension documents to make sure that they were listed correctly. They weren't overstated or understated. Where else would they go to? They would look at all remittances in, remittances out. So that's what the full audit trail would do.
And what product did you get from the audit team when you were deciding whether to suspend or to terminate?
I can't remember.
Or was it done by way of conversation?
It was I can't remember. The audit team might have a record of it. It would have been done over the telephone originally, and I would have gone to the contracts manager and said they'd had the audit or whatever.
Do you remember, that can come down, thank you. Do you remember being concerned about what Mrs. Wolstenholme was telling you at the branch, to an extent that you suggested that she maintained a mirror system, a manual record of transactions that she believed was being miscalculated by the Horizon system?
No, I don't remember that.
She's, Mrs. Wolstenholme, that is, has given evidence to the inquiry that you told her that you need to maintain essentially a side record in writing, a handwritten record of transactions, in particular the transactions that you feel have been miscalculated by the Horizon system. Do you remember that?
I do not.
Can we look, please, at poll 0011-8219? At page 165. This is a letter to her dated the 3rd of November 2000. And if we look at the second page, over the page, we can see it's your letter. Yes? And go back to the first page, please. So this is 2 days after you've been phoning the help desk. If we go to the foot of the page, please. In the last paragraph, you said, I must strongly advise you to immediately implement the checking procedures we discussed during my recent visits, i.e. the manual recording of data you feel has been miscalculated by your Horizon system and the recording of all error notices received using the pro forma I left with you. Can I also take this opportunity to advise you that accurate accounting within the office is your responsibility? And whilst I can advise you on best practice, the introduction of such practices lies with you. So it seems like you did tell her manually to record data that she felt had been miscalculated by the Horizon system, doesn't it?
It would appear so, but I think that was if I did, I don't remember it, but that would have been a good way of sort of double checking what was going wrong and what she thought was going wrong and what wasn't. I'm a recording of data. Yeah, so where she felt it had been miscalculated by Horizon system, she should have been recording it and recording all error notices received, because I left her a pro forma for that because they weren't bringing error notices to account.
Was it usual to tell postmasters to maintain a manual side record?
In this case, it certainly was.
So it was usual or was not usual?
It wasn't usual, but it was a double check to make sure everything was going correctly, that was being recorded correctly.
And did you obtain a copy of such a manual record from her?
I can't remember. I haven't got anything in the file, so I can't remember.
There's certainly nothing exhibited to your October 2003 witness statement concerning it. Can we go back to your witness statement, please, at same volume, at page 8? In paragraph 12, you told the court that Mrs. Wolstenholme persisted in calling the help desk, but these problems related to the use and general operation of the system and were not technical problems relating to the system. How were you able to say that the problems of which she was complaining were not technical problems relating to the system?
I would have asked the helpline. What sort of problems were they?
How would you have asked? Who would you have asked?
I would have asked one of the managers.
This is you telling the court that it shouldn't be concerned with any problems with Horizon, isn't it?
Is it? Where's the interpretation of that?
I'm sorry.
I don't understand what you're saying. Are you saying I'm telling them that?
Court, don't worry about Horizon in Mrs. Wolstenholme's case. All of her calls are about her use and operation of the system. They're not technical problems concerned with the system itself.
Right. Yeah, so.
And I'm asking you what evidence you had for that.
Because of the number of error notices that were coming back.
How does the number of error notices demonstrate that the dozens and dozens and dozens of calls that she made to the Horizon help desk did not concern technical problems?
Because they were like overstating of pensions or understating of pensions, or dockets were missing, or they were.
She wasn't
it was
calling the help desk about those, was she?
No.
She was calling the help desk about problems with Horizon. We've seen 3 calls today already where you joined in on the call, complaining about problems with Horizon.
Well, I took her word for it at the time.
So why did you tell the court that the problems of which she was complaining were not technical problems relating to the system?
What? Where's this? Which
It's on the
court?
screen.
I've not been to court. I haven't been to court.
Tell the court in a witness statement. This witness statement that we're staring at.
I'm sorry, you'll have to explain to me what I'm lost now. You'll have to explain to me what I'm supposed to be saying.
We've seen 3 call logs this morning where you yourself joined in the calls to the help
Yeah.
desk concerning problems with the Horizon system.
Yeah,
The latter of which was about the system adding a figure on rollover. Why did you tell the court that Mrs. Wolstenholme's calls were not technical problems relating to the system?
I don't know. I don't even remember that.
In the last
It-
paragraph,
it-
I'm sorry.
I can only surmise because of the number of error notices we were getting.
Okay. Last sentence in that paragraph, you move to problems at other branches. And
Yeah.
you say, whilst there were some problems at other branches, they weren't insurmountable, often due to the system crashing or general teething problems.
Yeah.
Where did you get the information from to make that statement in your witness statement?
Because I was visiting other offices to see how they were going on, and I was assessing it against that.
And so that last sentence is based on your experience of the other 111 branches.
At that time, I didn't have 111 branches. I think I only had 27.
Yeah, I'm not going to go back over that whole ground. I'm very grateful to you for the help you've given us. They're all the questions I ask. So I don't think there are questions from anyone else.
Is that correct?
It is.
Very well, then that's the end of your session, Mrs. Cotton. Thank you for coming to give evidence to the inquiry. I'm grateful to you.
Yeah.
So we now turn to the disclosure issue. I don't know whether it would be convenient to you to take a short break now.
Yes, by all means. What do you suggest, Mr. Beer?
Just 15 minutes so we can all reorientate ourselves in time and place.
Fine.
And deal with disclosure.
I don't know.
And so that means we return at 20 to 1, is that it?
Yes, thank you, sir.
Okay, fine.
Sir, good morning. Can you continue to see and hear me? So good afternoon.
Yes, thank you. Did you catch that, Mr. Beer? I can see and hear you.
Yes, thank you. I was just waiting for people to take their seats in the room.
Sorry. Yes.
After Mrs. Cottam, we were scheduled to hear from Mr. Stephen Bradshaw this afternoon,
Yeah.
Teresa Williamson and Mr. David Posnett tomorrow, and Miss Natasha Bernard on Friday. There's a significant and urgent matter that I need to raise before we proceed to consider the evidence of any of those witnesses. The core participants are aware of the issue because they were informed by the inquiry by email yesterday afternoon of the issue and received the correspondence that I am about to refer to yesterday afternoon, and the correspondence that was received overnight they received this morning. They're all aware that the inquiry has, in the time permitted, been considering it on an urgent basis. On Thursday afternoon of last week, the inquiry received a 5-page letter from the Post Office's recognised legal representative, Mr. Chris Jackson of Burgess Salmon, LLP. The letter was entitled Post Office Horizon IT, Post Office Disclosure, Structural Update as Incoming RLR, i.e. Recognised Legal Representative. It discussed a number of matters, and in particular, the letter addressed an issue that I'm going to refer to as the Microsoft Exchange 365 issue. A copy of the letter you have, sir, and has been provided to all core participants, so I'm not going to read it all to you now. In summary, it stated that the Post Office had been undertaking what was described as, quote, a structural review and, quote, related ongoing work, which had been referred to by Mrs. Diane Wills, the Post Office's Inquiry Director, in her witness statement given for the purposes of the disclosure hearing back on the 5th of September 2003. Mr. Jackson stated that the consequence of that work was, quote, data sources have been and continue to be identified, and the potential relevance of which will need to be assessed. The Post Office believes that its understanding is now significantly advanced. However, because of some factors set out in an earlier letter to the inquiry, and also difficulties with the availability of corporate memory within technical IT functions, the development of the Post Office's understanding and the potential relevance of further repositories, other data sources, and material not yet either fully harvested or fully reviewed continues. End quotes. Mr. Jackson noted, in particular, that he wanted to expand upon the Microsoft Exchange issue. As we understand it from that letter, the issue is as follows, and I'm quoting in large part directly from the letter. Firstly, Post Office, from the point approximately of demerger from Royal Mail Group in 2012, operated an email gateway platform called Proofpoint, which was similar to another platform called Mimecast. Proofpoint, quote, amongst other things, created an archive of all emails sent from or to postoffice.co.uk email addresses, sometimes known as journaling. The platform was, quote, intended and presumably believed to capture all emails sent and received, along with attachments during its period of operation, end quote. He continued, quote, the technology behind the interaction of these email systems is complex and is still being investigated. However, Post Office's current understanding is that Microsoft Exchange, and before that Lotus Notes, is the enterprise mail server that serves individual mailboxes as accessed by users through email applications such as Microsoft Outlook. Mimecast, and before that, Proofpoint, operates as an additional gateway between Microsoft Exchange and the onward and inward transmission of emails, and in doing so, performs various functions, including the journaling of all inbound and outbound emails. As a result, the Post Office explained that, quote, conceptually, platforms such as Mimecast should contain the fullest possible record of inbound and outbound emails, particularly given that they have much longer retention periods than Microsoft Exchange. In around 2016, Mimecast was introduced, and the Post Office understands that Proofpoint was migrated into Mimecast. On that logic, he continues, quote, there should have been continuity of email data in Mimecast from 2012 onwards. The Post Office understands, he said, quote, that Mimecast was used as the source for email harvesting for the inquiry and also for the group litigation. The Post Office understands that 300 plus email accounts have been harvested from Mimecast into the various parts of the Post Office relativity database for the various phases of the inquiry. However, and it's a significant however, first, queries by Herbert Smith Freehills relating to the account of Andrew Wise, which relates, we understand, to our initial inquiries about Appendix 6, which you'll remember from the spring. And secondly, in parallel with queries from Burgess Salmon and Field Fisher, the new RLR, in relation to a Section 21 notice concerning phases 5 and 6, have led to investigations by Post Office by and with KPMG. Those investigations, he says, quote, have now established that there are material volumes of email data that are in Microsoft Exchange, but that are not in Mimecast. And therefore, they are said to have been not available for search by the Post Office. Furthermore, he says, quote, the Post Office has not been able to establish why the proof point to Mimecast transfer did not provide the assumed continuity and or completeness. So the letter then explains that the total scale of the issue is not known by the Post Office because the email boxes harvested for all phases to date have been taken from Mimecast, and that the Post Office is currently investigating the number of custodians in respect of whom any emails are available on Microsoft Exchange. However, as an indication of the scale, KPMG carried out an analysis at the instruction of Burgess Salmon and Field Fisher and the Post Office against, quote, 13 of the 19 individuals named in a Section 21 notice from the inquiry sent in July. This is relevant to upcoming phases of the inquiry, so phases 5 and 6 for next year. And the Post Office gave us information in this letter that the remaining 6 of the 19 individuals were said not to have had Microsoft Exchange accounts. So using that forward-looking scoping, Mr. Jackson said, quote, the latest analysis indicates that there were approximately 363,000 parent emails that are not held in Mimecast. That's after deduplication following a standard forensic deduplication approach. It does not indicate the number of documents that are potentially responsive to that Section 21 notice or which require review. He says, in the light of those findings, the relevant 13 email accounts are being reviewed by the Post Office. The Post Office is due to provide its response to our Section 21 notice by the 8th of November this year. That notice, as I've said, was sent in July this year, and the deadline has been extended twice. So members of your inquiry team met with members of the Post Office and their legal teams on Friday, the 3rd of November, Friday last week, the day after this update was received. And the Microsoft Exchange 365 issue was discussed. Myself and another member of the council team stressed that the inquiry needed more information on an urgent basis to know if there were further documents from the Microsoft Exchange 365 platform that related to this week's witnesses. So never mind looking at 13 of the 19 individuals that are relevant to a Section 21 notice that concerns phase 5 and 6. What about documents that may be relevant to the witnesses we were about to call in this phase, phase 4? The solicitor to your inquiry asked that the Post Office inform the inquiry by 5 p.m. on Friday the extent to which the Microsoft 365 issue may affect or afflict this week's witnesses. At 5:19 on Friday, the Post Office, via Herbert Smith Freehills, wrote to the inquiry and noted, quote, we have run address book searches on Microsoft Exchange 365 for all of the witnesses giving evidence in the week commencing the 7th of November. These searches will run for the individual's email addresses and any aliases within the address book on Exchange 365. No Exchange data has been located for the witnesses scheduled to give evidence next week, other than Stephen Bradshaw and Dave Posnett. Peters and Peters have completed their review of the material identified using these searches for Messrs. Bradshaw and Posnett, and they are working with KPMG to produce these documents today if possible, or as soon as possible thereafter. We understand from Peters and Peters that production is currently expected to comprise of approximately 500 documents. The Post Office is urgently running further searches for the witnesses for whom no material could be found via an alternative mechanism, namely party-based searches i.e. searches based on who was a party to an email. Out of an abundance of caution, this secondary mechanism will also be run in relation to Mr. Bradshaw and Mr. Posnett. No data was found using this search for Ms. Cottam. The Post Office is still testing whether other search mechanisms might yield further documents, e.g. proximity searches based on the name which appears in a person's email address. This work is being conducted urgently. We'll provide a further update and any documents that have been identified on Monday, the 6th of November. At 8:24 p.m. on Friday, the inquiry received 421 documents from the Post Office. And at 9:01 p.m, the Post Office provided a cover letter to the production of those 421 documents, explaining that these documents were identified as a result of address book searches on Exchange 365 relating to Stephen Bradshaw and Mr. David Posnett. So those documents that were received late. They are said to respond to Rule 9 notices made by the inquiry on the 3rd of December 2021, the 15th of June 2022, and the 17th of August 2022, with a small number of documents said to be otherwise of interest. It goes without saying that those documents were extremely late, in some cases responsive to requests for disclosure made by the inquiry nearly 2 years ago. It also appears that some of them may be materially similar, however, to other documents already disclosed by the Post Office. So members of your legal team worked over the weekend to review those 421 documents ahead of this week's witnesses. That's part of a pattern of work to try and ensure that these Phase 4 hearings can go ahead as planned. And in Mr. Blake's case, who had the lion's share of the 421 to read, tireless work. The position yesterday afternoon was that the inquiry was proposing to proceed with all of the witnesses listed to be heard this week. Mr. Blake and I had got on top of this new material, the 421 documents. At 8:29 p.m. last night, the Post Office sent a further letter to the inquiry. Given its significance, I am going to read the relevant parts of it into the record. If you've got it, sir, it's letter 8:29 p.m. last night from paragraph 2 onwards. In our email of the 3rd of November 2023, we provided an update on the production of documents from Exchange 365 in relation to the witnesses who were giving evidence in the week commencing the 7th of November. We explained that the Post Office had conducted address book searches, i.e. searches run for individual email addresses and any aliases within the address book on Exchange 365, and was urgently running additional party-based searches, i.e. searches based on who was a party to an email, in relation to this week's witnesses. We're writing to provide a further update in relation to the witnesses giving evidence this week. The Post Office does not currently anticipate producing any additional documents from Exchange 365 in relation to Elaine Cottam, Teresa Williamson, or Natasha Bernard. However, for the reasons outlined below, the Post Office is unable to provide the same reassurance in respect of Stephen Bradshaw and Dave Posnett. The letter then addresses the position of Elaine Cottam in its paragraph 4. As we've heard from Mrs. Cottam, I'm not going to read it. Moving on to paragraph 5, under the heading Stephen Bradshaw, Tuesday the 7th of November 2023. On Friday the 3rd of November 2023, the Post Office produced 382 documents. Just stopping there for your note, that's part of the 421. Documents tagged as relating to Mr. Bradshaw as a result of the review of the material identified following address book searches for Mr. Bradshaw. Over the weekend, the Post Office conducted further party-based searches to seek reassurance that no additional material was captured by these searches. Unfortunately, the party-based searches have returned a very significant volume of material apparently relating to Mr. Bradshaw. It's not been possible to process the data, so it has not yet been possible to ascertain the level of internal duplication, the extent to which the material might overlap with documents already harvested by address book searches and data otherwise available in POL's relativity databases. However, it is anticipated that there may be new material within that data. Work is being urgently undertaken to conduct further analysis of that data in order that the position can be established. Further, given it has not been possible to process the data, the Post Office has not been able to run search terms or conduct analysis to identify the volume of new material. Regretfully, there is no prospect of the Post Office being in a position to review or produce any relevant material as a result of party-based searches before Mr. Bradshaw is scheduled to give evidence tomorrow. Further, the Post Office is not in a position to provide any reassurance to the inquiry that no additional relevant material exists. As soon as the Post Office can provide the likely volume of additional material that needs to be reviewed, it will provide the inquiry with a time frame within which the material can be reviewed and produced. The Post Office is prioritising this a matter of urgency. Teresa Williamson. The Post Office has not identified any Exchange 365 material relating to Teresa Williamson as a result of the address book or party-based searches. David Posnett. On Friday, the 3rd of November, the Post Office produced 5 documents relating to David Posnett following the address book searches. The party-based searches run over the weekend have resulted in the identification, harvesting and processing of 22,000 parent emails after deduplication at MD5 hash level. It's likely that some of this material will be new, and POL is working to identify the extent of any new material it will be necessary to review. Regretfully, the Post Office anticipates it will not be possible to review and produce any new material resulting from the party-based searches sufficiently in advance of Mr. Posnett giving evidence on the 9th of November. As with the data for Mr. Bradshaw, the Post Office is prioritising this as a matter of urgency. And Natasha Barnard, the Post Office did not identify any material following the address book searches in respect of Ms. Bernard. Party-based searches run over the weekend resulted in the identification of approximately 640 parent emails. Search terms applied to this material resulted in no relevant material being identified. A manual search is being completed overnight. However, the Post Office does not expect the position to change in relation to Ms. Bernard. Lastly, we will update the inquiry further, including in relation to the witnesses giving evidence next week, as soon as possible. Lastly, at 11:14 p.m. last night, the letter I've just read was from Herbert Smith Freehills. The letter I'm about to quote from was from Burgess Salmon and Field Fisher. They wrote to us at 11:14 p.m. last night, albeit the letter is dated the 7th of November today. They say, they write further to the Herbert Smith Freehill letter in advance of the hearing today. Quote, the inquiry's most pressing concern will of course be phase 4 hearings currently underway. Under the heading Microsoft Exchange, they say, quote, the current knowledge in respect of the data held on the Post Office's Microsoft Exchange servers is addressed in the Herbert Smith Freehills letter that I've just read. The Post Office apologises that it's only been able recently to provide a greater level of information about the impact of the data located on the Microsoft Exchange repository. As explained in our letter of the 6th of October and the 20th of October, whether or not the emails were new required complex technical knowledge and work. At the time of that correspondence, and as is still the case, the extent of duplication is unclear. The Post Office and its external advisors are working on a proposed approach to address the issue in terms of impacts on disclosure, and will update the inquiry by the end of this week. And then there is some information about still further other data sources. The information given to the inquiry at 8:29 p.m. last night is plainly very significant information. I'm going to invite you in a moment to hear from Ms. Gallifant on behalf of the Post Office, and then from any other core participants who wish to make submissions, and then, if I may, I'll reply. But for now, I would note the following. On the basis of what the Post Office, through its various lawyers, have said, there appears to be no reason why the inquiry cannot proceed to call Teresa Williamson or Natasha Bernard. In the light of the information that I've just read, you'll appreciate why we proceeded with Mrs. Cottam just now. In relation to Stephen Bradshaw, the letter of last night does not state how much material has been returned by these recent searches relating to Mr. Bradshaw. It simply says there is, quote, a very significant volume. We understand that the work undertaken by the Post Office to date suggests there is a pool of documents which is very large indeed, i.e. a very high number of documents on which to conduct a deduplication and then a relevance exercise. I would invite Ms. Gallifant to inform you of the Post Office's current understanding of how large the pool of material is. Secondly, in relation to Mr. Bradshaw, he is a significant witness who has a footprint against a large part of the inquiry's relevant period and is involved in a number of important events of significant interest to the inquiry. Thirdly, there are a number of emails already in possession of the inquiry where we would dearly like to have seen the replies or follow-on emails. In relation to Mr. Posnett, as I said, we thought over the weekend we had addressed the new material relating to Mr. Posnett that came from this data source. But it seems that there is a pool of some 22,000 documents to be looked at. That's after duplication, and it is parent emails. And you'll note the significance of that a parent email can itself be the source to many, many more documents if those documents are attached to an email. That number, 22,000, is a very high number indeed. Mr. Posnett is a very significant witness, scheduled to give evidence for a day and a half, again involved in a series of significant events of interest to the inquiry. Both of the witnesses I've just mentioned, Messrs. Bradshaw and Posnett, are witnesses whom I would have invited you to give the self-incrimination warning to on the basis of material already within our possession. This material was not, on the face of it, disclosed in the course of the group litigation, despite, as we understand it, Mimecast being the source for the harvesting of emails in the group litigation. The non-disclosure of this material, if it turns out to be material non-disclosure, may be a matter to which we will have to return in phases 5 and 6 of the inquiry. This material was not, on the face of it, disclosed in the course of the appeals to the Court of Appeal Criminal Division, and the same point may apply. As for the Post Office, I would invite them, in addition to the point I have made already, to explain, firstly, in clear terms, their present understanding of what has gone wrong here. Secondly, to give their assessment of the likely relevance of this material to Messrs. Bradshaw and Posnett. Not, of course, on the basis that they have read it and analysed it. They haven't got to that stage yet. But because they possess it, they know the date ranges concerned. They know the probabilities of whether we have or have not seen this material before. And they know the extent to which there are gaps in our disclosure from 2012 onwards. And thirdly, to give their judgment by way of submission to you as to both the feasibility and the appropriateness of calling Messrs. Bradshaw and Posnett without disclosure of this material. You will have seen that the letter of 8/29 last night said that the Post Office, and I summarise, can give the inquiry no reassurances whatsoever. I would invite them to assist you with the opposite issue, namely an assessment of the likelihood of these caches of documents containing material that is relevant to Messrs. Bradshaw and Posnett. So that's all I say for now. I would invite you to hear from Ms Gallifant first, then the sub-postmaster representatives, and then any other person, any other core participant who wishes to make submissions.
All right. Well, Ms. Gallifant, it does seem to me appropriate for me to invite you to respond to what Mr. Beer has just said.
Thank you, sir. Yes, I intend to. So I'm not going to go back over the correspondence, which Mr. Beer has very helpfully outlined and summarised for you, save to note one point, which is, as in a letter from Herbert Smith Freehills of the 20th of October of this year, it was a general catch-up letter in relation to a number of disclosure issues. At that time, initial sampling had indicated that there was significant overlap between data held on the Mimecast archive and that held on Microsoft Exchange, or sometimes it's referred to as Exchange 365. It wasn't until very recently that the differences and the potential for an absence of overlap was identified. Post Office fully recognises the importance of the inquiry, of witnesses and other core participants having proper notice of new documents prior to a witness giving evidence. It deeply regrets that it finds itself in the position where its position is, in the case of Mr. Bradshaw and Mr. Posnett, that simply isn't possible to do this week. The position, as Mr. Beer has indicated, is different in respect to Ms. Cottam, who of course has already given evidence this morning, Ms. Williamson and Ms. Bernard. We agree with the analysis that there is no reason why their evidence should not continue to be heard in accordance with the schedule this week. And for the avoidance of any doubt, the additional checks that were indicated would be carried out overnight last night have been carried out, and there are no documents to be produced from Exchange 365 in relation to either Ms. Williamson or Ms. Bernard. I am not in a position, sir, to explain to you what has gone wrong. I can assure the inquiry that many people have been seeking to ascertain why this apparently anomalous distinction between what is held on Exchange 365 and what is held on Mimecast has arisen. I am told it is a deeply technical and complicated question for which there has yet not been identified a simple answer. That is why, for the time being at least, while obviously inquiries continue into trying to work out what went wrong, we have focused in the short term on trying to work out what we can do to seek to put the inquiry in a position to be able to continue with such witnesses as we are able either to produce relevant documents for in good time before their scheduled evidence, or to confirm, as per Ms. Williams and Ms. Ms. Williamson and Ms. Bernard, that there are no such documents to be produced. Can I start then with Mr. Bradshaw? The number of emails identified from the party-based search, as distinct from the earlier search on an address book basis, in other words, not looking for emails that are tethered to the address book which is contained within Microsoft Exchange, but is simply a search for any person, in this case Mr. Bradshaw, who was either the sender, the recipient, or copied into or blind copied an email. It is indeed very extensive indeed. It is approximately 2 million documents. It is important, however, for me to emphasise that that number in itself casts serious doubt on the extent to which this dataset contains duplicates and or false positives, given the inherent unlikelihood that Mr. Bradshaw would have sent, received, or been copied into that number of emails, even over the very significant number of years for which he's been employed by Post Office. The sheer volume of emails identified have meant that it is not yet possible to process the data. The reason is a practical one. The amount of it is too large to transfer to Post Office's third-party e-disclosure specialists, KPMG, for processing. So it has not yet been possible to ascertain the level of internal deduplication that's required within those results, nor whether there are false positives or other issues with that data set. Equally, it has not yet been possible to ascertain the extent to which those documents might overlap with documents already harvested by the address book searches, approximately 380 of those documents which were disclosed on Friday, or data otherwise available in Post Office's relativity databases or already disclosed. In all the circumstances, having regard to the sheer numbers involved, it is anticipated that they may very well be new and relevant material in the data. What is required before that conclusion can be reached is that the data is migrated to relativity for review to seek to identify documents which fall within the relevant time period relating to the criminal prosecution's case studies following the rollout of Horizon, and to remove those which fall either side of this period. We're very conscious, of course, that Mr. Bradshaw was employed by Post Office both before and after the period in issue. We will need to remove false positive results. We will need to deduplicate the internal duplicates and then, to the extent possible, deduplicate against documents that have been reviewed and or produced to the inquiry already. We will then need to run search terms and then review documents for disclosure. I emphasise that isn't set in stone in terms of the order of those factors. That may differ depending upon the particular data sets and the size of them to come back. But all of those steps will be required. We are confident that the total number of any new and relevant documents will be vastly smaller than the current data set identified in relation to Mr. Bradshaw using the party-based search approach. And we note that that approach obviously has its limitations. That's demonstrated by the position in relation to Ms. Bernard, in which 640 emails were identified through the party search and 0 relevant documents identified from that data set. It may also assist the inquiry to have a sense of the delta between documents identified using an initial search, in this case the party-based search, and subsequently identified as being relevant and disclosable by comparison to the numbers involved in the address book search relating to Mr. Bradshaw. By way of starting point, when that primary search was undertaken, around 23,000 documents were identified as relating to Mr. Bradshaw. I'm instructed around half of those were parent emails, the rest attachments. Search terms were then applied, resulting in approximately 600 documents for review. And after that review, as you've been informed already, 382 were produced as being relevant. So that is less than 2.2%, about 1.6% of the initial data set. Now, I'm not saying that the inquiry can extrapolate from that that will be the same when it comes to going from the extremely large numbers identified in the party-based search, but it may provide a useful context to note that the numbers have, when they have started quite high, come down very markedly indeed. The real question then becomes, how long will this take? Mr. Bradshaw's case is a particularly complicated one because, as I've said, we haven't yet been able to put it onto relativity. But, of course, all endeavours are being made to overcome that particular technological issue. All work is being undertaken as fast as it can be in order to assess the position in relation to Mr. Bradshaw. However, it is highly unlikely that we will be able to identify any new documents by the end of this week, and certainly, of course, obviously, not in time for him to give evidence today or tomorrow. I can assure the inquiry that Post Office will continue to work around the clock and through the weekend in order to resolve this issue as fast as possible. The position with Mr. Posnett is simpler in the sense that there is no problem with the data being reviewed, that it is already on the relativity platform, and of course the numbers are very, very considerably smaller. But again, it is not going to be possible to go through all the required steps to identify only those new and relevant documents before he is due to give evidence tomorrow. We profoundly regret that that is the position. I've been asked by Mr. Beer, for understandable reasons, how likely it is, we say, that the relevant documents will be identified for Mr. Bradshaw and Mr. Posnett. It is very difficult, sir, to give an indication of the likelihood of that event, but it does seem to us simply as a matter of common sense. One certainly cannot rule out there being a significant number of potentially relevant documents in these cases.
When you use the word significant, Ms. Gallifant, just so that I get a feel for what we're talking about, are you there talking of upwards of 10, upwards of 100, upwards of 1,000? What sort of ballpark are we in?
Well, if one looks at the way in which the searches have reduced to a relatively small number of documents, we would have thought it would be hundreds rather than anything more than that. But I am speculating.
I'm not holding you
wildly.
to
No, I'm
I
grateful.
just
That's
wanted
exactly.
to know what you meant by significant,
Yes.
that's all.
So, it will be more than 10, it seems to us, inevitably. But more than 100, probably. More than that, I really would be making it up as I go along, I'm afraid.
All right.
But it just seems to us as a matter of common sense, looking at the scale of the numbers, the period of time covered, particularly in relation to Mr. Bradshaw, it seems to us a matter of common sense tells us there are likely to be relevant documents as a result of these matters.
And although I appreciate your difficulties in making an assessment of which will elapse between you getting Mr. Bradshaw's documents on relativity or some other, or in any other way being able to assess their relevance, can you give me a kind of timescale in the sense of, are we talking about days or weeks or what?
So I think it may be that we have to take this in stages because I'm sure we can tell you within a couple of days whether or how we've managed to transport it to some other repository such that it can be analysed, which it currently can't in the way that it is stored. It may, depending on the numbers then, after deduplication, that will be what tells us then how long it will take to go through those processes that I outlined, sir, to go through the deduplication, internal deduplication processes, to then go through search terms, to then go through deduplication against documents already produced to the inquiry or otherwise held, and then to actually review the documents before working out what pool, hopefully a pond rather than a pool at this point, of documents are left. So I would hope that we'll be able to update you at each stage of that, sir, but I think it would be remiss of me to overpromise and say it will be by X date. We are doing it as quickly as we humanly can.
All right.
I'm also invited by Mr. Beer to indicate Post Office's judgment on the feasibility of calling Mr. Bradshaw or Mr. Posnett without the disclosure of this material. We so respectfully agree that it wouldn't be appropriate, even if CTI had, as it were, advanced it as a possibility, it wouldn't be appropriate to proceed in the absence of this material having been provided to them and to other core participants.
Ms. Gallifant, although Mr. Beer didn't say so expressly, I gained the strong impression from what he said that he didn't think it was appropriate that either of those witnesses should be called prior to further disclosure. And everything you've said to me effectively suggests the same.
Exactly. So we too had understood that to be Mr. Beer's position, and it is our position as well. And that's why I started by emphasising that we fully recognise the importance of all people in this inquiry, the inquiry team primarily, but also other core participants, in having proper and full access to these documents as early as possible before giving evidence. And I should mention, of course, we recognise the inconvenience to witnesses themselves where late disclosure is made. That has happened on a regrettably large number of occasions, and we apologise for each of those occasions.
The last thing that I'd like to ask you is that there are witnesses who are not too far down the line in terms of when they're due to give evidence.
Yes.
Who might fall into the same category, if I can try and put it as neutrally as possible, as Mr. Bradshaw and Mr. Posnett, i.e. having important evidence to provide to the inquiry, but might also be discovered to be in a category of witness where disclosure is not yet complete. That's very convoluted, but you know what I mean.
I do, sir. Can I start with next week's witnesses?
Yeah.
Separating, first of all, Catherine Oglesby, who, of course, is another civil rather than the criminal case studies witness.
Yeah.
Address book searches for her have returned nil hits. There are no hits for that. Party-based searches have been conducted for the period 2003 to 2009. 724 documents have been identified. Those have all been reviewed and found not to be relevant. We are running additional party-based search, in other words, the alternative perceived to be backup search if you can't find documents on a, the backup, additional searches in this case for the latter period, which is 2009 to 2016. We will review any additional documents coming out of that time period as a top priority with a view to producing any relevant documents this week. Mr. Utting and Ms. Staple are procedurally in the same boat. Address book searches did not yield any returns. Party-based searches have been requested. We are awaiting the results of that search. We hope to have those tomorrow. It will review any documents identified as a top priority with a view to producing any relevant documents this week. Mr. Whitaker, we are still awaiting the urgent conclusion of an address book search. That's the primary search approach for Mr. Whitaker. But we have already requested the backup, from abundance of caution, party-based search as well. As with the other witnesses scheduled for next week, any relevant documents identified as a result will be reviewed as a top priority. The other witness next week is Mr. Tatford, Warwick Tatford, who's independent counsel, not an employee of Poll, and therefore no address book search has been undertaken, as he wouldn't have a post office .co.uk address. Instead, a party-based search has been requested, for which again post offices were awaiting the results, and as with the others, we hope that those will be available tomorrow, and we will be in a position to review them as a priority and disclose any documents this week. So that is, as it were, the next stage, and I've spoken then about this week's witnesses and next week's witnesses. Can I just, although I wasn't invited to do so, perhaps give you, Sarah, an indication of the question that I'm sure Sarah will have in your mind, which is what happens then? Can I just flag, as Mr. Beer has done, the letter from Burgess Salmon from later last night, setting out some of the other potential, and I emphasise the word potential, disclosure matters in relation to the number of further potential repositories. Post Office has always sought to be open and transparent with the inquiry as to potential further sources of relevant documents, as well as the difficulties associated with some of them. We cannot rule out the existence of some relevant documents in these repositories before harvesting and analysing them. But that said, based on Post Office's experience in relation to the backup tapes, which, as you'll be well aware, Sarah, have been the subject of extensive and intensive review over the last month or so, it may well be that there are very few relevant documents ultimately found to be held on those repositories that have not already been harvested, reviewed and produced to the inquiry. The Post Office notes that when the issue of the backup tapes arose shortly before the evidence of Miss Chambers on the 26th of September this year, you adopted, Sir, what might fairly be described as a constructive and pragmatic approach by continuing to hear her evidence, subject to 3 points, and indeed the evidence thereafter of other witnesses. The first was the need for close monitoring of the disclosure process during the remainder of the inquiry. The second was the potential for witness evidence in relation to the backup tapes for the purpose of the disclosure hearing scheduled for January 2024. And the third was the potential for the inquiry to request further witness statements or recall witnesses back to give further evidence in the event that relevant material is disclosed after a witness has given evidence, or if disclosed beforehand, where the inquiry has not had the opportunity to process it. And I'd respectfully add to that, where also other core participants would not have had the opportunity to do so, and the documents are of such relevance that they should have had that opportunity before the witness gives evidence. So it may be that you consider a similar approach would now be justified in all the circumstances. Post Office equally recognises that given the particularly sensitive and important stage which the inquiry has reached in Phase 4, and the potential significance of the data held on Exchange 365 for a number of witnesses who played a key role in a number of the criminal prosecution case studies, as well as issues potentially arising from further repositories, you may consider it be more appropriate to adjourn the hearings more generally, following hearing from such witnesses as it appears to be at least common ground for this week, can be heard in the meantime. We would respectfully suggest that any such decision is made in the light of the fullest information that Post Office can put before the inquiry as to the scope of the work required to analyse the further repositories and the number of documents involved, as well as, of course, the matters in relation to the Exchange 365 issues on which we are hoping to update the inquiry as soon as possible this week, both in relation to next week's witnesses and potentially thereafter. As we noted, in our view, it's possible then to proceed with the 2 more of this week's witnesses without any issue arising, and potentially possible to continue with next week's position of the witnesses proceeding. We will confirm that as soon as possible. The inquiry may think in these circumstances that that is the appropriate point when we have provided more information to the inquiry, dependent upon current searches and inquiries, at which to determine whether to press on with such witnesses for whom there are no relevant documents to be found on Exchange 365, or for whom relevant documents have been identified and disclosed in adequate time for the inquiry and other core participants to process them, or to adjourn Phase 4 generally. We submit that the timing of that decision and the point is once the position is clearer in relation to next week's witnesses. That is subject to 2 points. First, it could be suggested that Mr. Jenkins could give his evidence in relation to Phase 3 as currently scheduled. Post Office fully recognises any such decision would need to be informed by submissions from his representatives as to the desirability and/or practicability of splitting his evidence in this way. The inquiry may wish to note in this context that Post Office is currently reviewing documents which have been found in Exchange 365 in relation to Mr. Jenkins via the party-based searches, he obviously not being an employee of Post Office, and there may be a not insignificant number of documents in the hundreds, I believe, to be disclosed before his evidence currently scheduled for the end of November, beginning of December. Post Office should be in a position to produce any such documents next week, but we can obviously provide updates this week in that respect. Secondly, it may be that Mr. Atkinson, King's Counsel, could also give his evidence in relation to the criminal case studies, which we understand will be based on contemporaneous documents rather than evidence to be heard in this second part of Phase 4. However, I would emphasise that we consider these to be very much matters for the inquiry rather than Post Office to make any particular submission upon. I would like to conclude by reiterating Post Office's profound regret that this situation has arisen, and by apologising frankly to you, sir, the inquiry team, the witnesses affected by these issues, and to the other core participants and their representatives for all the undoubted inconvenience caused. Thank you.
Thank you. Now, it seems to me to be clear that both Mr. Beer and Ms. Gallifant provide strong reasons why Mr. Bradshaw and Mr. Posnett cannot give evidence this week. And therefore, my very strong preliminary view is that I should postpone their giving of evidence. But if any core participant, either present or represented, wishes to argue against that and wishes to argue that either or both should give evidence and then, if necessary, be recalled if further documentation comes to light, I would like to hear them articulate that now, so that if my preliminary view is to be shifted, it's shifted sooner rather than later. So does anybody wish to advance that possibility?
I've been asked to convey some instructions from my clients, which doesn't relate to that issue, but I don't know if you could hear me briefly on those points.
Well, we'll come to any other points,
Thank you,
Mr.
sir, yes.
Speaker. I'm not shutting everyone up at this stage. I'm simply trying to deal with matters in a way that at least appears to me to be logical. So does anybody, in effect, wish to oppose me postponing the evidence of Messrs. Bradshaw and Posnett? Right, well, clearly no one does. And so I say now formally that they will not give evidence this week. They will give evidence on dates to be fixed in the light of how we proceed with disclosure issues. Now, so far as the general issues which have been raised by Mr. Beer and Ms. Gallifant, the core participants will have had some opportunity to grasp what is going on, just as I have. But in respect of what Ms. Gallifant has said, and indeed some of the suggestions she has made as to the future conduct of the inquiry, I do not expect anybody to respond with any definitive submissions, because I want everybody to reflect upon how best we should proceed in these difficult circumstances. But all that said, if there are co-participants like Mr. Jacobs, or representatives, I should say, of co-participants like Mr. Jacobs, who wish to make, and I stress the word, short submissions about where we are, then now is the time for me to hear them. And I stress the word short, not to in any way minimize the seriousness of the situation we find ourselves in, but simply because I take the view that these issues are dealt with after reflection and not in the heat of the moment, so to speak. So that I will hear short submissions, but I stress the word short. So first of all, Mr. Jacobs, since you've already indicated a wish to make some submissions, over to you.
Thank you, sir. I act for Shazia Sadiq, who sits to the right of me next to Mr. Steen. Her case is affected by the actions of Mr. Bradshaw, and she travelled with her husband today to the inquiry, leaving quite early this morning, both taking time off work to do so. We have also taken instructions from Joan Bailey, who can't be here today but is following remotely. And we've taken instructions from both of these clients on the documents that were available. Yesterday, Howe & Co had a client with 58 of Howe & Co had a conference with 58 of our clients, and their overriding concern in relation to the Phase 4 hearings is what they describe as corporate amnesia. They are worried that witnesses are saying, I had nothing to do with this case, I don't remember anything about it, it was a long time ago. And what has reassured them is that the documents that the inquiry, and we saw it this morning, puts to such witnesses are able to assist greatly in establishing the facts. So in relation to what has been said by Ms. Gallifant this morning, it's not a matter about core participants not receiving proper notice. We say we must have disclosure in good time in order to properly represent and act for our clients. And one of the concerns that our clients have in relation to these recent events is the timing. We heard from Mr. Beer this morning that in relation to Mr. Bradshaw, the inquiry was notified at 8:24 p.m. on Friday that there were 382 documents in relation to Mr. Bradshaw. At 8:29 last night, the inquiry was told that there are very significant, there's a great volume of material in addition in respect of Mr. Bradshaw, and there was further communication at 11:14 p.m. last night. So we saw with Mr. Jenkins in July that the Post Office located large numbers of documents and notified the inquiry of this practically right before Mr. Jenkins was due to give evidence. So this is the second time with Mr. Bradshaw that this has happened. Our clients are concerned. They do not want an adjournment, but they accept that it is far better to prepare questions for witnesses and to have conferences and for them to give their instructions when we have all the material available. So they would prefer that matters are delayed so that we can have proper disclosure. But another concern that they have is that they are worried that there seems to be a pattern emerging now whereby the Post Office, very late in the day, and this is the second time it's happened the day before a witness is due to give evidence, informs the inquiry that new disclosure is available or has become available. Our clients say this is simply good enough, this is simply not good enough, I ought to say, and would ask whether the inquiry can impose a mechanism on the Post Office to prevent what they see as abuses of the disclosure process by the Post Office in this inquiry. I conclude by saying that we have made representations on disclosure dated the 19th of December 2013 and the 2nd of February 2013. And one of the things that we said is that there is a perception from our client group that the Post Office is seeking to control these proceedings through frustrating the disclosure process. And that is our client's concern, and I'm instructed to raise that with you. Essentially, they say this isn't good enough and they would like the inquiry to do whatever it can do to ensure that this doesn't happen again. Thank you, sir.
Well, Mr. Jacobs, there have been occasions in this process when I have felt like trying to rewrite some of the inquiry rules, but I am bound by them, and it's not part of my terms of reference to rewrite them, unfortunately. All right. So does any other legal representative wish to make similarly short submissions?
So yes, please, but I assure you they'll be very short.
That's all right, Mr. Maloney. Just wait till you're on camera with me, if you would, please.
Thank you, sir.
No, you are, fine.
Thank you. So once again, we're faced with a disclosure failure by the Post Office, and as always, it impacts our core participants. We've also already met with core participants to receive their input into the anticipated evidence of the two witnesses most affected by this non-disclosure, and it's obviously very frustrating for all of them. Our primary concern, on behalf of the core participants we represent, is to ensure that the inquiry fully investigates the issues before it, whilst maintaining momentum so that our core participants receive the inquiry's conclusions within a reasonable time. We're of the view that the course proposed by Council to the inquiry is most likely to meet our concern, and we therefore endorse it. But we have one request to add, sir, as you would expect. As we go forward, we ask that any new material is provided to core participants in good time for them to assist the inquiry with the relevant witnesses. That's all we wish to say, sir.
Thank you, Mr. Maloney. Ms. Page, I can see you just beyond Mr. Maloney, as it happens. Do you wish to make submissions?
Also, very briefly, sir, to say first of all that I support everything that's been said already by those acting for sub-postmasters before me, but also to let you know, let the inquiry know that Janet Skinner sits beside me. She travelled down yesterday. She has stayed overnight in a hotel. Travelling and moving around is not particularly easy for Mrs. Skinner, and it also takes a toll emotionally, and it's draining. So we ask, above all, that if this pattern continues, Post Office gives proper notice so that people know it's coming up and that they don't travel. It simply isn't fair. Secondly, I would ask also that some consideration is given to past witnesses. In the scrabble to make sure that the inquiry hearings are able to maintain some sort of momentum, it's important to remember that there's been quite a number of witnesses already in phase 4, leave aside previous phases. And I'm thinking in particular of the case study of Lee Castleton, where nearly all of the witnesses have already given their testimony. And so it's important that we don't forget that there may be some very important and significant documents which weren't put to them.
Yeah,
Thank you. That's all I wish to add.
thank you. Anyone else wish to make submissions?
Ms Dobbin.
Yes.
Jenkins. As you know, sir, in a series of submissions to you, we set out our concern that he was being asked by the inquiry to provide a witness statement and also to give evidence on oath before you when disclosure was an evolving picture. My learned friends may not know this, but you will, that a very detailed draft witness statement was submitted on Mr. Jenkins' behalf only this week. We wrote to the inquiry on the 26th of October prior to that submission to try and ascertain what the position in respect of disclosure was and the extent to which there might be outstanding disclosure which was relevant to his position. We can only say on his behalf that having submitted that draft statement to the inquiry, we are alarmed and profoundly concerned to find that yet again there may be another substantial body of material relevant to him that has not yet been disclosed. And I think it's important that we make that clear on his behalf now, that this may have important consequences in relation to that. I'm grateful to you, sir.
Thank you, Ms. Dobbin. Anyone else?
No, there is.
Before I ask Mr. Beer whether he wishes to exercise the right he reserved to himself to reply.
Thank you, sir. Can I now exercise not a right, but a request to further address you?
Yeah.
In relation to Messrs Bradshaw and Posnett, I had not set out the position of counsel to the inquiry clearly, and that was deliberately so. That's because it was not my application to adjourn these witnesses. We, as your counsel, want to get on with the business of calling witnesses. We, as your counsel, want to get on with the business of progress in this inquiry. But the conduct of one of the core participants is presently standing in our way. Accordingly, as has now occurred, it should be that core participant who is standing in the way of the inquiry, who is preventing progress in the inquiry, who should come to the inquiry and state plainly that its own conduct is preventing progress. This is, of course, the latest in a series of disclosure failings by the Post Office. They may be forgotten to many. They're etched in the memory of those who sit on this side of the room. Hard copy documents found in new Post Office locations. The use or the misuse of search terms when conducting the disclosure exercise. An improper deduplication exercise. A failure to consider families of documents when giving disclosure. A failure to disclose blind copyees to emails. The failure to give disclosure of documents held on backup tapes. The failure to give disclosure of native emails. Looking at this latest disclosure failing, we say, having heard from all of the core participants, that the following factors confirm the preliminary indication that you gave. Firstly, the date range. It seems, on what we know now, this repository of material to concern emails from 2012 onwards. What we have seen in the inquiry so far, when we have been allowed to see materials after 2012, is that important material is generated in the years after 2012, not only about the reaction to the unfolding scandal, described by some as a cover-up, but such material also relates to events before then. It's a reflection backwards to what people were saying and doing at the time, i.e. from 2000 to 2012. Secondly, the means of communication here, emails. We have found that some employees and staff of the Post Office speak rather frankly and openly when they communicate by email. Not quite at the level of some WhatsApp communications, but approaching it. It has been so far, the email traffic, a rich seam of evidence with which to ask witnesses about their conduct and their state of knowledge. This is email communication, and therefore we consider that it is likely to contain important data sources to be able to test if such witnesses adopt the position, their claims that they have no present recollection of the events about which they are being asked. Thirdly, sir, the individuals concerned, as I said already, Messrs Bradshaw and Posnett have a heavy footprint on important events that the inquiry is considering. For those three reasons taken together, we do submit that you should adjourn these witnesses' evidence. So far as the past is concerned, we are completely aware, this is a point made on behalf of the Hodge, Jones and Allen core participants, we are completely alive to the point that this new discovery does not relate only to the present and the future. It relates to witnesses who have already passed in and out of the witness box. And we will be on top of the Post Office in ensuring that they give disclosure that relates to those who have already given evidence. As to the future witnesses, we would counsel you against making any big decisions now. Nobody has asked you to do so. We were only told about the scale of the issue by the Post Office at 8:29 p.m. last night. The information which the Post Office gave you in the letters, as supplemented by Ms Gallifant helpfully today, is still not sufficiently clear or complete in order to take big decisions as to the way forwards. As to the immediate future after this week, i.e. next week's witnesses, you'll recall that the letters from the Post Office said that they would update us by the end of the week on the position in relation to next week's witnesses. The end of the week is frankly not good enough. We can't wait until the end of the week to know whether we're calling witnesses on the following Tuesday. For next week's witnesses, I would invite you to direct that by 5 p.m. tomorrow, Wednesday, the Post Office must state in relation to each witness for the following week whether searches have been undertaken of either of the varieties mentioned by Ms Gallifant, and if there are documents to disclose them by that date. So that's all I say for the moment.
Thank you. Well, let me confirm that I propose to postpone the evidence of Mr. Bradshaw and Mr. Posnett. I cannot today fix any date or even likely period when that evidence will be given, since it's dependent upon more detailed and up-to-date information from Post Office about the extent of the disclosure which may be relevant to those witnesses. The other persons who are scheduled to give evidence this week will give evidence. So that means there will be a witness tomorrow and a witness on Friday. I accept the good sense of Mr. Beer's suggestion that I should not make any big decisions, in quotes, today about the future conduct of Phase 4 or anything else. As I say, I need time to reflect upon all that has been said and all that is occurring in quite rapid sequences before I make any big decisions. as to when the post office should provide the next update to the inquiry, which is the last point touched upon by Mr. Beer. The suggestion in correspondence, Ms. Gallifant, was an update by the end of the week. But I think Mr. Beer has a point when he says that that's getting perilously close to when the evidence should start next week. So unless you seek to deflect me from it, I think you should update me at the latest by 12 noon on Thursday. That's giving you a little more time than Mr. Beer suggested was appropriate. But I think in all the circumstances, that's fair enough, so to speak, and gives us sufficient time to know where we're going next week, or at least sufficient time for me to make a sensible decision about where we're going next week. Is that acceptable to you?
So I'm very grateful for that extension to midday on Thursday. Can I just flag up, Mr. Beer asked for an update as well as the documents themselves to be produced by his deadline. I suspect that there may be a tightness in that timetable for the actual documents to be produced. We will do everything that we can to do that, but if we are able to offer an update with an indication of when the documents will be produced, that may be what we have to do. But I'm simply saying that from an abundance of caution, because maybe we can tell you the position, but we can't get you the documents precisely to that time. But we will strive to do what, sir, you have asked us to do, both in terms of update and the documents in accordance with the time frame you've indicated.
All right, thank you. And then finally, I'd like to extend my apologies to the two core participants, Mr. Jacobs' client and Ms. Page's client, who travelled quite some distance, I imagine, to be at the inquiry today to hear the start of Mr. Bradshaw's evidence. It is extremely frustrating for you both to find yourselves in this position, and you have nothing but my sympathy in these circumstances. I think that's all that I propose to say at the moment. So we'll start again at 10 o'clock tomorrow morning, Mr. Beer?
Yes, that's right. So we'll make inquiries as to whether any of the three witnesses for this week can be now bunched up a little, so we can hear them on 2 days rather than 3, and we'll let the core participants know if that's the case.
Well, I'm sure that everyone would think that a good idea if you can bring it to fruition, so that's fine.
Thank you, sir. 10 o'clock tomorrow.
Fine. Thank you all.